I just have 2 for Don.
Okay, gotcha.
I don't know why I have 2.
I don't either. Who knows?
Hey, Commissioner.
Are y'all aware of, we're about to have a big procession coming in here? Do you know this?
Don.
Yeah, I didn't know. I didn't know. So, okay. All right, we good? We live? Okay. Well, good morning. Welcome to the Tuesday, January 28, 2025 Tarrant County Commissioners Court meeting. And I call the meeting to order.
Tim O'Hare, County Judge.
Present.
Roderick Miles Jr., Commissioner Precinct 1.
Here.
Elisa Simmons, Commissioner Precinct 2.
Here.
Matt Krause, Commissioner Precinct 3.
Present.
Manny Ramirez, Commissioner Precinct 4.
Yep.
Constitutes a quorum.
All right, thank you very much. We have a special start to our meeting today. I'm now going to introduce the Tarrant County Sheriff's Office Honor Guard and the Fort Worth Police Department Bagpiper. Please rise as they come in to lead us.
Detail, halt. Ready, face.
And now to lead us in the singing of God Bless America, please welcome World War II veteran, Corporal Don Graves.
God bless America, land that I love. Stand beside her and guide her through the night with a light from above. From the mountain to the prairie to the ocean, wide we go.
To lead us in our pledges and our invocation, Tarrant County Sheriff's Office Chaplain Wes McDuffie.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I pledge thee, Texas.
Honor the
Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible. Let us pray. Father, we thank you. We thank you for all that you've done for us and all that you're doing. Father, we realize that we're really blessed. As we look out over the hills and the mountains and we see our friends in California and all about, Lord, as they're going through the different tragedies that they're experiencing, loss of death, loss of homes, Lord, lives ruined. But Lord, we often talk about us and how we're just going through. But when we look at the people that have lost everything, Lord, it'll get us in different perspective of where we are. So, Lord, we just want to say thank you for what you're doing for us right now. The little things that we were talking about don't mean anything because we serve a great God who can do anything but fail.
Yes.
So, Lord, as we pray for this, your Tarrant County, we pray that you keep us, Lord, that you watch over us, you protect us. Lord, that you encourage our leadership and you give them the wisdom and understanding to take us where you would have us to go. Now, Lord, I pray for all law enforcement everywhere, that they go out and protect and serve.
Yes.
I pray for the citizens of Tarrant County and abroad, Lord, that you'll continue to be that watch in the night and in the day. So, Lord, we thank you this day for all of our veterans, Lord, right now. It's in Jesus' name I pray. Amen.
Amen. Thank you.
Order! Up! Ready, face! Up! Up! Left! Left!
Thank you. You may be seated. All right, Mr. Merritt, agenda announcements.
Good morning, Judge and Commissioners. A few announcements this morning. Item G1, we're going to hold that item until after close. G1.
Is that from consent?
No, sir, it's not. It's an individual consideration. And also, court members, a couple of items that we are pulling from consent for individual consideration. Item D5 under Budget and Risk Management. G2 under the Criminal District Attorney section. Item K1 under Juvenile Services. And item N29 under Purchasing.
On G1, I am going to comment on it before closed and after closed.
Yes, ma'am.
Okay?
Any other questions on agenda announcements? Okay. Thank you, court members.
What did he just move G2? All right, do we have any announcements from Commissioners Court? Anyone? Okay, now we come to our proclamations, resolution, and presentation section, and we have a special presentation to honor Don Graves this morning. Commissioner Ramirez.
Yes, so very excited to have Don Graves with us this morning. Everybody heard him sing, and there's no better patriot that I know than Corporal Don Graves. Whereas the freedoms and security enjoyed by citizens of the United States today are the direct result of the sacrifices made and the unwavering vigilance upheld by the men and women of the United States Armed Forces, and whereas more than 80 years ago, a generation of Americans was called upon to serve during World War II, and so at just 17 years old, Don Graves answered that call by enlisting in the Marines and serving in some of the most grueling and unforgiving conditions of modern warfare. And whereas Don served in the 2nd Battalion, 5th Marine Division as a flamethrower and was honorably discharged in 1946 with the rank of corporal, and whereas Don currently dedicates his time to inspiring and educating others by sharing his military experience as a speaker, minister, and a singer and entertainer. And whereas today we gather to honor and reflect now and forever, let us pay tribute not only to Don, but to all veterans by upholding the ideas that they fought to protect, and by offering them the care and respect that they so rightfully deserve. Now therefore be it resolved that we, the Commissioners Court of Tarrant County, do hereby issue this proclamation to honor Don Graves and extend our gratitude to him for his lifelong service to our nation, state, and community. In witness whereof we have hereunto set our hands and caused the great seal of Tarrant County to be affixed this 28th day of January 2025, and I would move for approval.
Second.
All right, we have a motion and a second. Any discussion? All right, please cast your vote. All right, passes unanimously.
Thank you so much. And before I ask Don to come up and take some pictures and say a few words, I did want to make a few announcements. First of all, I want to honor and recognize every single veteran that's in attendance here today. If you're a veteran, could you stand up so we can give you a round of applause? Thank you very much. And I also want to make the announcement that on February the 3rd, we'll be hosting our second annual Veterans event in conjunction with the Fort Worth Stock Show and Rodeo, where we bring together thousands of veterans and vendors to provide any service that you can think of that would serve some of our vendors. Their last year's event was incredible. We have an amazing team that put it together from our office, and so we're looking forward to a great event this year. And one other special milestone we're celebrating this year that has to do with Don is that he will be 100 years old on May the 3rd. Don, I'm going to come down and take some pictures and say a few words. Congratulations, Don. Would you like to say anything? You don't have to, but you can.
He does.
I'll switch with this connect. This is the second one that I've had within a week. This is wonderful. I say this is the second one I've received within a week. They inducted me into the Hall of Fame of Texas. I just want you all to know, born and raised in Detroit, Michigan, went through the Great Depression. The war came along, walked out of school, went off to the United States Marine Corps, did our job, came home, got married to a little gal. She took advantage of me. And lo and behold, I started singing, and I used to do impersonations of all the singers, the popular singers. And I had a great time and a great life. My wife and I were married 72 years. 72 years. She had bipolar. I did not know this until after she passed away. She was in a nursing home. She passed away. The head nurse came to me. She said, "Don, did you know your wife had bipolar?" I said, "What is that?" We didn't know what that was at the time. And she explained it. And I said, "Oh, yeah, that explains a lot of things." And I said, okay, from now on, she was a sweetheart. She couldn't help anything else that I didn't like. They can't control themselves. But God bless America. I was next to a Jeep on Eagle after we cleared the beach. And a Jeep went by with a radio on. Kate Smith was singing God Bless America. Irving Berlin wrote that song for her. I fell in love with that song. And I call it our other patriotic song. Marines and sailors and Army boys, we all sang that song when we went to the slop shoot. You Marines remember what the slop shoot was? That's where we get refreshments. Sir, can you come here a minute, please?
Coming down.
Gee, that felt good. I want to give you something. God bless you. God bless all of you.
Thank you, sir.
And I see all smiling faces. And after the last 2 days, no wonder we're smiling. I'm telling you, I've been praying for this day, just where our country is going back, where we may even become a republic again, and tell them what to do. We're paying them, we ought to. I'm looking forward to a good America before I leave this country. God bless all of you. Thank you so much for everything.
All right, well, a good start to the morning. Next up is a recognition of the 2024 Leadership Development Program participants. For all of you who are here today, and show of hands, how many of you are here today? Good. As I call your name, please stand. And forgive me if I don't get it right. Jihan Abdallah, Viviana Acosta, Susan Autry, Kamisha Bailey, Rugatu Berry, Monty Bilby, Ronnie Boland, Emily Kane, Sean Collerman, Rashara Carey, Jessica Carrillo, Larissa Carroll, Madhavi Chadalawada, Ashley Fletcher, Patricia Gamboa, Felicia Guerrero, LaChandra Hallman, J. Harkey, Brian Hollers, Nikki Jones, Marion Lanig, Twyla Lee, Mark Lukey, Caitlin Malik, Mitchell Molinar, Sergio Munoz, Ian Patterson, Hunter Trotter, Jacob Wilson, Iris Yang, Susan Young, and Daisy Zamora. Congratulations and thank you for going through this. We appreciate you very much. And I don't think there's anything we have to vote on, but thank you for doing this, and we appreciate your commitment to Tarrant County. All right. Next up, we have our consent agenda.
Move for approval.
We have a motion to approve the consent agenda as amended.
Second.
We have a second. Any discussion on the consent agenda as amended? All right, seeing none, please cast your vote. All right, passes unanimously. Brings us to a public hearing to consider establishing a speed limit of 35 miles per hour on Timberview Drive in Precinct 1. So this is a public hearing. It is now open. I don't have anyone signed up to speak to this item. Is there anyone who wishes to speak to this item? All right, seeing none, I'll entertain a motion to close the public hearing.
Move approval. Second.
We have a motion to close the public hearing and a second. Any discussion? All right, seeing none, please cast your vote. All right, passes unanimously. Can y'all shut those doors out there? All right, next is another public hearing to consider establishing a speed limit of 25 miles per hour in the South Fork Estate Subdivision, phases 1, 2, 3, and 4 in Precinct 1. So it's a public hearing. I now open the public hearing. I do not have anyone signed up to speak to this item. Is there anyone who wishes to speak on this item? All All right, seeing none, do we have a motion to close the public hearing?
Move approval.
All right, we have a motion, do we have a second?
Second.
Motion to second to close the public hearing. Any discussion? All right, please cast your vote. Passes unanimously. Next up is item 10A1, which is consideration of the appointment of the Tarrant County Fire Marshal.
Good morning again, court members. As the judge just read, this is a request to appoint Kenneth Wilson as the Tarrant County Fire Marshal for a 2-year period beginning January 28th of this year.
Move to approve.
Second.
All right, we have a motion and a second. Any discussion on this? All right, please cast your vote. Passes unanimously. Item A2 is consideration to submit an appointment to head of department form to the Texas Commission on Fire Protection regarding the newly appointed fire marshal.
Yes, sir. This is a companion item for the item that was just passed by the court.
Move for approval.
Second.
All right, we have a motion and a second on this item. Any discussion? All right, seeing none, please cast your vote. All right, it passes unanimously.
Congratulations, Mr. Wilson.
And Mr. Wilson, would you stand? Let us recognize you. Welcome aboard. I know you were already with us, but welcome aboard in your new capacity. Do you have a guest with you?
Yes, this is my wife, Jenny.
Hello, thank you for letting us have him. Appreciate you. All right, next up is consideration to adopt the Tarrant County decorum policy.
Move for approval?
Second.
All right, we have a motion and a second to approve this item. Any discussion?
Yes. So, we've all heard the saying, power tends to corrupt, and absolute power corrupts absolutely. There are two major checks and balances to government: transparency and the First Amendment right to free speech. This court decorum policy places way too much discretion on to one person, and that's Judge Tim O'Hare. And it discourages freedom of speech with the barrier of inconvenience. In this policy, the time limit is at the discretion of the judge. The speaker order is at the discretion of the judge. The judge can excuse a speaker, and I quote, for any other matter at the discretion of the judge. I am not okay with this, and neither should any member of this court be okay with this. This allows the suppression of voices under the guise of order. The public is not fooled by this. I've gotten lots of calls and emails. This court should not be fooled by this facade either. For the first thing, the time limit needs to be left alone. For 3 minutes, can we not sit here as elected officials and hear from the people who've taken off work, left their children, if they were at home taking care of elderly parents, whatever? Can we not sit here and for 3 minutes listen to the people that elected us to these very nice paying jobs we have? We can sit here and listen to you guys. Next is the inconvenience of suppression. We're asking constituents to come the day before and register to speak, and then come back the next day to speak. Now, we do offer online registration, but there are some people who cannot register online or do not have access to a PC. So for those who are employed and want to speak, we're asking them to take 2 days out of their lives to come up here and participate in a process that should be very accessible to them. And third, in this policy, constituents place their precinct information on these forms, and Judge O'Hare has the authority to decide who speaks in what order. That is not okay with me.
Anybody else have any comments?
I appreciate all the folks that have reached out to me. I appreciate all the folks that are here to speak to this and stand up to this. But finally, in this policy, the bailiffs can criminally trespass anyone from this building without any direction from a court member or staff. This does not allow any checks and balances, and that should be for anyone. So again, no commissioner on this court should be okay with this policy. It takes control from every member of this court. Subtly suppresses the voices of you guys through inconvenience and places power solely in the hands of one person. I did give input into this. I provided input to county staff. I don't see a bit of it in the damn policy. So you can tell who's in control, and you can tell who wields the power, and you can tell that county staff is terrified of him. And so this is what you get. But just know that before you all even contacted me, I was opposed to this. And so I stand with you, and I hope you stand with me in opposing this.
That is literally some of the most ridiculous stuff I've ever heard uttered. I am currently the presiding officer. There are statutory powers and authorities that come with that. I've been here 2 years. I receive a pile of papers every morning as they scatter to get it to us all and make 7 copies of it. I have never taken a single person out of order except for 2 times when 2 elected officials asked. One was Royce West, one was Beau French, and I allowed those to come up because they said they had a conflict. I don't intend to ever move the order. I'm sitting here running the meeting and looking through this while you all sit here. I've never pulled one out, stuck it under, but you have the same order that I have. The idea that this is run by me, all 5 people have feedback, and I realize it's difficult for you to understand you're not in the majority on the court. And so our county administrator does not work for each one individually. Our county administrator works for the court as a whole, and they take feedback and they put together the best thing they can put together based on feedback. And the notion that county staff is terrified of me is the silliest thing I've ever heard of in my lifetime. I believe I run a fair meeting. It's strict when it comes to yelling out. I will continue to run a fair meeting. This is not designed to somehow give me the ability to pull some fast one. I'm a firm believer in free speech. Free speech is not the ability to disrupt a meeting anytime you want to disrupt a meeting. It is not the ability to scream out. And the United States Senate, the United States House, the City of Fort Worth, the County of Dallas, the Texas House of Representatives, the Texas Senate, all have policies and procedures in place to keep people from yelling out. And then the notion that this policy creates the ability for law enforcement to go enforce laws is also ludicrous. We don't have the authority or power to give law enforcement powers or take law enforcement powers away. What they choose to do when it comes to enforcing laws is up to them, and that separation of powers that you're concerned about would actually be violated if we tried to tell them who you can prosecute, who you can't prosecute, who you can arrest, who you can't arrest. I have never told anyone from the sheriff's office to arrest someone or do anything other than remove them from this proceeding when they speak out. So I will continue to do that, which is my right to do, whether this policy is passed or not, as the presiding officer of the court.
Can I ask a question, Commissioner Simmons? I'm new to this, so if this is out of order, let me know. But I practice constitutional law, so I take that very seriously, especially on free speech issues. And you had said that it violates the First Amendment. Can you tell me where in the rules what the violation is of the First Amendment? Because if we are violating the First Amendment, I don't want to sign off on it, but I didn't see anything in those rules that did that. So if you can show me where it violates the First Amendment, that would be very helpful to me.
Like I said, there are subtleties, but to me they're not subtleties. When you prevent or you erect barriers for people to speak, that is a violation to me. So coming down the day before, signing up, having to spend time out of 2 of your days to come and speak, that's
Okay.
a violation.
So you're saying there's things you definitely disagree with in the policy that to you raise serious red flags, but not necessarily a violation of constitutional law. Am I understanding that correctly?
There are things in this policy that raise red flags, and I think I detailed them.
Okay. Thank you.
In terms of and I'll say this to the public, and in terms of if there is anyone that doesn't have the ability to sign up online, you can call my office, and unless this policy prohibits it, we will sign you up. So if you call my office, no matter who you are, what party you're from, whether you support me, don't support me, we won't check, we won't know, we won't care. If you call my office because you can't get to a computer prior to whatever the time thing is, which I did not put in here, by the way, but if you call our office, we'll sign you up. So, and you have my word that we will do that as long as you call us before 5 p.m. If you call us at 4:59, I don't know if we can make the cutoff, but if you'll call us the day before, we'll sign you up.
In addition, this policy does not address things like weapons in this courtroom. It does not address things like, is that podium accessible? So this policy lacks some things.
I would agree that the policy is not perfect, but I will say this. I think that consistency matters and having policies matter. So the substance of it, if we want to change the substance or you want to perfect it, going forward. But I do think the public deserves policies. They deserve to know what to expect on any given meeting. On the time limit side, what I heard from a lot of people was that when meetings run all day long, they have to take the entire day off. And so that was almost a convenience factor to get more people to be able to speak and sign up. If you can limit that, or I don't know how else to do that, so that people don't have to take the entire day off of work to come make their voices heard. But again, I think that there are things that the judge speaks on that are absolutely true. Almost everything in here is basically memorializing the authorities that he has as the elected presiding officer. I didn't see anything in there that was an overreach by the county judge. I mean, he could do any one of those things right now in this court at any given time and make an exception to any rule with a vote of 3 at any given time. So it's just, maybe I'm not as passionate about the policy or the substance. I just think that the public deserves to know what the policy is, and that's for everything that happens in this county. Folks should be able to pull something up and say, how does this work at court? How long do you have? When can I sign up? They deserve a policy. The court deserves a policy. So the substance, to me, if we have to change it, tweak it, fine. But the issue is having a policy in general is what I agree with, because I think the public deserves that.
So the policy, I'll tell you, I I think I was the first one on this court to broach a policy after the judge kicked out Chanel Johnson the first time. I couldn't make it to that parking garage quick enough before I called Mr. Cradaville and asked, how is this court meeting governed? Is there a policy? And he said, no, it's governed by Robert's rules. And I said, you've got to be kidding. And so my staff got policy from Travis, Dallas, Harris County. So I've looked at those. I agree. I'm the very first one that broached the topic of we need a decorum policy here. And so the others that I have gone through from the other counties are not this turn over power to the county judge. There are actions that we can take as a court. We can make a motion. If he wants to kick out the Johnson speakers again, we can make a motion to not do that. And so that none of that is listed in this policy. So if there's going to be a policy, which I advocated for, I was the first one, then it needs to be comprehensive.
I'll say during my 10 years in the Texas House, I sat on several committees, some chaired by Republicans, some chaired by Democrats. They all, as the presiding officer, wielded this exact same power and authority. They were all able to cut off debate when they wanted to. They were all able to take witnesses out of control if they wanted to. They were all able to do things, as Commissioner Ramirez said, by virtue of being that presiding officer. There were times when the chair was not in the chair and the vice chair, who happened to be of a different party, sat in the chair. They were imbued with the powers of the presiding officer as well. They could take things out of order. They could limit discussion. So I don't really feel like there's anything in this policy that is overbroad and overreach. It's just basically what the powers of a presiding officer are, which, again, I'm sincere. If there's something in here that violates a constitutional provision, please let me know, because I take that very seriously. I just do not see that in this policy.
And I've not been in the State House, but I'm in a number of organizations, and the chair cannot cut debate. There has to be a motion from the body. So that's how that works.
Well, I think you're right on that a motion from the body can alter. I mean, the court as a whole, 3 votes controls what occurs, no matter what composition that comes from.
Correct.
So even if, so I guess what I'm saying, kind of your concern too, even if there is a policy in place that outlines expectations, there's nothing that says on any given Tuesday, 3 votes can't go against what the policy is. I mean,
Correct.
Well, with several exceptions, though, and that is we don't have the power as a court to say, Matt, you're no longer the Road and Bridge Commissioner for your precinct. We've decided 3 votes, you're not. Sorry.
Yeah.
You cannot legally do that. And there's certain things when it comes to the legal presiding officer, you can't just take the rights away. I've said this before, I'll say it again. I will fight like the Dickens for any statutory power given to me to never lose it, and I will not advocate to gain additional powers that the state law does not provide. But I take that role seriously. All right, any other comments from here before we go to speakers? All right, the first speaker on this is Robert Bucher. Following Mr. Bucher, Matthew Mucker.
Congress shall make no law respecting establishment of religion or prohibiting the free exercise, therefore abridging the freedom of speech or of the press or the right of the people to peacefully assemble and to petition the government for redress of grievances. It doesn't say it has to be nice, doesn't say it has to be clean and concise. That's why we had 1776, because of issues like this. We should be able to speak. And yes, 3 minutes is not a long time, but that's what we established, and I'm okay with that. But to want to, if we get too many speakers here, it is what it is. That's what we pay y'all to do. This is what our taxes pay y'all to do, to sit here and listen to us. Policy doesn't make it right. Sorry, it doesn't make it right. You may, one policy just so it makes you feel good, but it doesn't make it right. That's why we have the Constitution. That's our checks and balance. But if you want to continue to give one man power, one person power, one woman power, no matter what they are, you're doing way too much, and you're stepping out of line. Thank you.
Following Mr. Mucker, we have Joe Palmer.
Members of the court, excuse me. I was not aware that this was on the agenda this morning, so I don't have any prepared statements. My primary concern here is that, as others have said, the right to petition the government for the redress of grievances is a constitutionally enshrined right. In my experience addressing boards such as the court and other government agencies, 3 minutes really is the bare minimum amount of time necessary to put together an argument and to present it in a convincing manner to my elected representatives. I think you would be doing the public a great disservice if you had the authority to arbitrarily change the amount of time that a speaker had without sufficient notice. I can't write a 3-minute speech, show up to the court and say, oh, there's only 2 minutes on the clock. Now I have to decide what to cut and how to present my argument. Well, I've got pen and paper on my lap here in the gallery, okay? So I'm unaware of any other elements of the proposed policies, but I caution you to think very carefully before you do something like change the amount of time a speaker has without giving them sufficient notice. As I said, I think 3 minutes is the bare minimum necessary. And as Commissioner Simmons mentioned, right, it is your job to listen to your constituents, right? It is your job to sit there, no matter how many people have signed up, it is your job to listen to our arguments as we exercise our right to address our government. So those are the only comments I have. As I said, no prepared statement. I appreciate your time. Thank you.
Thank you. Following Mr. Palmer, we have Charles Bills.
Thank you, Judge, Commissioners. Joe Palmer, Tarrant County. Don Graves said at the beginning of the meeting, I'm looking for a good America before I leave this country. I think we ought to give it to him. I think one of the qualities of good leadership, matching the scope of the response to that of the issue. These proposed rule changes are way out of scope. In fact, there was not a problem of any kind during the last meeting, except for the violent removal of 3 attendees. Incidentally, neither the professor nor Manuel Mata were coming up in the online system as having been arrested, and no bond amount was indicated through the next day. Were they actually arrested? Were they unarrested? When we remove people from meetings against their will, who have broken no laws, what does that mean about us? Since these are being proposed now, I have to think that they are arising from the last meeting. The first gentleman who was removed at the last meeting was correct. Section 551007 of Local Government Code enables any member of the public to address the body on any agenda item either before or during the body's consideration of that item. Somebody signed up to speak on proclamations. He was denied that right. Imagine getting violently removed from a public meeting and or arrested in America for simply asking why the law is not being followed. Where did these proposed rules changes come from? I think we know that by now. When did you first receive them? You had input. That answered my question. Your input was ignored, it sounds like. These proposals give too much autonomous power to the county judge. They're also intimidating and will serve to discourage people from coming to these meetings and speaking freely. Again, there was no problem at the last meeting. It appears that your response to loved ones becoming scared for their family and friends' safety in the jail is to extend that fear to affect their attendance at these meetings. Before this whole thing went down, I would have guessed a sensible approach would be to be extra accommodating, consoling of your grieving community, assuring them that you see the problem and are working to resolve it. It's ironic that coming to rightfully express outrage about the jail deaths could itself land you in jail. It doesn't look good, in my opinion, as a conservative activist, to shut down speech by implementing these unnecessarily strict rules. You aren't responding to what the people want by implementing these rules. They did not come from us. Nobody asked for this. The people want you spending time focusing on the jail, not on coming up with reasons to kick people out of meetings they paid for. Commissioner Kraus, I'd like to address your question about the constitutionality. It does address Congress. It says Congress shall make no law. I believe that the constitutional argument here is the spirit of the Constitution. The spirit of what guys like Mr. Graves fought for, is that being followed? Is that being adhered to? You have the ability, and one last point, If these things are inevitable, if he has this power and you don't even need to vote on it, why are you voting on it?
Right.
You have the ability to make a decision here. No autonomous authority, not one more farthing of autonomous authority to the county judge. It gets dispersed among the county commissioners. If not, y'all can all just go home and ask him to fund your bridges and stuff.
Thank you. Following Mr. Bills, we have Dorian Geiger.
Okay, there's a few issues on this, but one, as far as the order of people speaking, I don't really have a problem with that. If it's elected official or if it's anybody, if they ask politely, can they please be put in early because they have a conflict, I'm sure you're okay with letting them go ahead and speak. So, having someone come in or sign up 5 o'clock the previous day, it has never been a problem that I've seen. I know one time that there was like a bunch of people speaking and wanted to speak, and they weren't, the papers weren't ready. I remember that but that was like a one-time thing, and I don't think that that's really an issue that needs to be fixed. Having it like 9:30 the morning, they can get the copies out in plenty of time. So I don't see any need to change that. And what I do think, as far as maybe not constitutional, but I've spoken at the city council, I've spoken at the Fort Worth ISD, they all have a 3-minute set. And I know if there's a lot of speakers, they'll cut it down to 2 minutes. But unlike the ISD and the city council, you guys are paid pretty handsomely. So I think you can stand, like Ms. Simmons said, Ms. Simmons, that you can stand to listen. I mean, it's only been a couple times I've noticed since I've been speaking that there were a lot of speakers, and it lasted well into the afternoon. And when that case happened, that means there was a lot of people coming for the first time to speak, and they should get to speak. Cutting it down to 2 minutes is not egregious, but then cutting it down to 1 minute really is. I mean, it's maybe not constitutional, but it's, it's people want to speak, and giving them enough time to speak is important. And I don't think it's enough of an inconvenience to have this policy. Thank you.
Thank you. Following Ms. Geiger, we have Harriet Harrell.
My name is Doreen Geiger, and although I am a member of the Tarrant Justice Network, my words are my own. I read all of the new proposed rules of decorum and want to ask that the rule requiring people who want to sign up to speak at Commissioner's Court be changed to, quote, all requests must be submitted online or in person by 9 a.m. the day the court meets. Some people cannot sign up online and need to do so in person. It is not feasible for some people to come downtown twice as the proposed rules require. A 9 a.m. deadline before the court meets for in-person forms and online forms will still give staff an hour to make copies for each of the members of the court.
All right, following Dr. Harrell, we have Carla Palomares.
I'm Harriet Harrell, and one of the things that I appreciate about Commissioner's Court is its openness to citizens. We are welcomed to come and to participate. We feel like we're partnering with you to make our county a better place. There is a policy or a set of rules online now which allows a respectful relationship. This proposed policy changes that. Its tone is restrictive and punitive. While the court communication specifically says the policy is to maximize citizen participation, it actually minimizes it. It makes it more difficult for potential speakers to sign up. It focuses on the way the county judge can limit speakers and choose who speaks when. And it puts the county judge, you, Judge O'Hare, not the policy, in the horrible position of being perceived negatively whenever the policy is enacted. As far as disruptive action, which really rarely happens, I recognize that a serious disruption of court proceedings justifies corrective action. But this proposed policy needs to more clearly delineate what such disruption is. And for someone issued a criminal trespass warning to have to appeal it to the Cara County Sexually Oriented Business Board? Really? Now, I understand that that board may be changed to deal only with appeals. My goodness, fast, rewrite this thing. Don't let people think that you are deliberately demeaning them. As strongly as I can, I urge you to delay voting on this policy. I believe that you care about the citizens of Tarrant County. So pay attention to this input that you're getting today. If you simply vote up or down today, after the input that you're getting from the people impacted, it is a slap in the faces of all of us. You are hearing citizen input, which should be a part of such a policy. Do not ignore it. Please move to table or delay a vote on this policy until you can treat this feedback with respect. There's no immediate urgency to change the current rules. Working collaboratively to revise it would be a huge move to create respect.
Following Ms. Palomares, we have Stacy Mello.
My name is Carla Palomares, Precinct 4. I'm a little too frustrated to be here right now. Was just rushing to get over here. As a regular working class person, you know, as Commissioner Simmons and many other people have already said, it takes time and effort out of our days to show up here twice a month to try to talk some sense into all of you sitting on this dais. And I think it's absolutely retaliation that's coming from you, Tim O'Hare, trying to pass these policies behind closed doors, having no collaboration with any of your other commissioners, having no public input prior to this being proposed. It is absurd. Every single time we come to this meeting, we are trying our best to comply with our decorum policies, to try to urge you and move you in some way, but you have zero compassion for community. You have zero regard for the people who have died in our jails, for the people that are constantly being harassed by our sheriff. It's absurd, and even though this policy may pass today, we're still going to show up. We're still going to talk your ears off. We're still going to keep you here because you're getting paid by our tax dollars to show up and to stay here and listen to what the heck we have to say. So regardless of how much time we have on the clock, we're going to show up and we're going to make our voices heard, and you're going to sit there and you're going to listen to us over the next 2 years, and hopefully by then we'll have you out of here.
Yeah. Who's next here? Following Miss Mello, we have Reed Bills.
Okay, hello, court. I'm here. I'm one of the people, one of your constituents who took off work, sat in traffic, paid for parking to be here. And I think it's really ridiculous, to use your word, Judge O'Hare, that you are telling me that that sacrifice is only worth, in some cases, 1 minute of your time. Is that what you're telling me? Okay, so you expect me to summarize everything that I have to say, in some cases, in 1 minute. Judge O'Hare, I would like to ask you, when you were just giving your whole spiel about why you're in support of these guidelines, do you think you could have done that in 1 minute? What about 3? Because that's currently what we have right now. Do you think you could have done it in 3? Okay, I'll answer it. No, I don't think you could have. I think it was way more than 3 minutes that you had. But for some reason, you want to further restrict the time that we have to speak to you all. And And in some instances, this is the only place that your constituents have to speak to you, because some of you are very involved in your community. I'm looking at you, Commissioner Kraus. In this past election cycle, you were nowhere to be found in the community. I think you were a little too busy banning books. So I think some people probably need as much time with you as possible to get their point across and make their needs heard. Okay? So all that to say, I think that timeline is absolutely ridiculous. Secondly, this decorum guideline states that Judge O'Hare would be free to cut off people whenever he feels like it, at his own discretion. So now, not only do we have 3 minutes or less to speak, now, Judge O'Hare, you can cut off anyone willy-nilly, at your own discretion, right? So if someone says something that you do not like, you have the power to silence anyone. Does that remind anybody of a certain type of leadership style? Anyone from the court want to help me with that? Okay. Gotcha. So, all that to say, if you are not able to sit there for 3 measly minutes, which is all we have right now to speak to you, you should resign. And open up the seat to somebody who is willing to sit there and listen to their constituents. Because please remember that it is your constituents who voted you into the seats that you are in right now, and it is your constituents that can vote you out. So please stop wasting time trying to silence them. Thank you.
If you do it again, you'll be removed. So following Ms. Bills, we have Bishop Kirkland.
I have reviewed the proposed policy and find the following provisions to be unacceptable and intended to inhibit public presentations before the court. The time limit for speakers should not be reduced below 3 minutes. If speakers take the time to sign up and come to speak at the meeting, sitting through literally hours of county business and paying at least $10 to park, they should be given no less than 3 minutes of the commissioner's time. The deadline for submission of the public comment form should be 9 a.m. the day of the meeting, leaving at least an hour for staff to get the form to the presiding officer. I will note that first come, first serve has never been followed in this courtroom in the time I have been coming to speak. For instance, I signed up yesterday to speak, and my son Charles signed up this morning, and he has already been called to the podium. So that one doesn't fly. I also ask that the form that we need to fill out to speak accept autofill input. It does in 2 instances, but you have to write out your name and your address and your phone number and all that. An earlier deadline is appropriate for written comments on agenda items to allow distribution to commissioners and time for them to read the comments before they vote on the issue. Speaking order should be strictly first come, first served. The presiding officer should not have the power to discriminate between speakers and select privileged individuals to have priority to speak ahead of others. No public forum should allow such bias. The presiding officer can apparently eject a speaker for any reason or no reason at his discretion. There should be some limits to this authority. I agree that clapping is disruptive and wastes time. For that reason, I suggest that clapping for proclamations, resolutions, and employee recognitions be limited to the end of the presentation. The presiding officer can ask that applause be held until attendees are given a signal to clap at the completion of the particular ceremony. In addition to my comments on decorum, I ask that you return the benches to the hallway outside the courtroom. They provide important assistance to speakers called from the overflow room and waiting for their time at the podium, as well as a place to sit for various reasons for people who have taken time from their day to visit the court.
Thank you. Get him out. He's removed. All right, Bishop Kirkland, if you'll give it.
Ms. Bills, you're absolutely right. I signed up.
Bishop Kirkland, will you give it just a minute here?
Sir, can you get a camera out of the way?
Ms. Beals, you're absolutely right. I signed up late Friday night, early Saturday morning, and you spoke before I did. The background of this policy says the intent of this policy is to ensure maximum citizen participation. Please, sirs and ma'am, do not piss on my leg and tell me it's raining. My parents did not say that I was a United States Marine. They didn't even say I was in the military. They used to tell their friends I was in service. As a United States Marine, I was obligated as a servant. Whatever craziness the Marines ordered me to do, I did it as a servant because the mission was always more important than the Marine. Tarrant County average salary is minimum salary is $69,160, which is 59% higher than the country's average. With that, we pay you people a whole lot of money to pretend to listen to us for 3 minutes. This is not China. No one appointed you to this position. You chose this position. If you want the position, indulge 3 minutes to listen to your constituency. The Supreme Court has said that municipalities have authority to set rules for conduct and code of conduct and decorum. However, it must be equally applied. Brandenburg versus Ohio in 1969, the Supreme Court ruled that the government cannot punish inflammatory speech unless it's likely to incite an imminent lawless action. Texas v. Johnson, 1989, the court held that burning of a flag is a form of symbolic speech, by the way, which I hate. But if I could burn a whole flag, but I cannot speak for 3 minutes, is a problem. The second executive order that President Trump signed was restoring freedom of speech and ending government censorship. The purpose of the order was the First Amendment of the Constitution of the United States, amended essential that our republic enshrine the rights of the American people to speak freely in public square without government interference. I used to come here long ago. Sometime I was the only speaker. Then it got to be this. You must ask yourself, how did it get to be this? And why is it this? No more censorship or dictatorship in this world.
Robert Vann. And following Mr. Vann, we have Gerald and Jackie Cox.
Thank you, Judge and Commissioners. I just have, you've heard a number of suggestions for possibly modifying this this policy change that you're looking at now. And I just had a couple of things that I thought I might suggest. You might add something like, should 5 or more verified attendees wishing to speak on the same topic agree to permit one speaker to speak for that group, that speaker shall be permitted to speak for up to 5 minutes on that topic. This procedure would likely speed up testimony. It should take less time for one speaker to come forward and be recognized than for 5 or more individuals. A similar procedure is being followed in the city council meetings. It has been for a number of years. And they maybe have 10 speakers, and one speaker can speak for them for an extended period of time. On the public comment forums, I think other folks have pretty well covered this. 5 o'clock really is unrealistic because so many people work, so many people would have difficulty getting their forms in by 5 o'clock. I think that really is unrealistic, and that needs to be backed off. Several folks have suggested 9 o'clock the morning of. I would suggest perhaps start of business, I think, is normally 8 o'clock. But sometime the morning of the court, so that folks that aren't able to do the online forms are able to come in and actually only come in for one time to do that. So that would be my suggestions. Thank you.
Thank you. Ms. Cox.
Thank you, Commissioners. I'm Jackie Cox. Can you hear me?
Yes.
All right. There has been a request from Mr. Kraus that we be specific about identifying the First Amendment violations that we refer to. So I want to do that for him.
Thank you.
It begins with the fact that the United States Constitution protects the rights of free speech in a public forum, in a designated public forum. When state law sets up a governmental meeting and demands that the people have the right to speak in that meeting, state law has helped to create the public forum. You create the topic on which free speech is permitted when you set an agenda. So my right to tell you today what my complaints are against this policy is protected by the First Amendment to the United States, and it's protected by the Open Meetings Act. Section 551.007E of the Texas Open Meetings Act provides that a governmental body, like this one, may not prohibit public criticism of the governmental body, including criticism of any act, omission, policy, procedure, program, or service. The rules now before you do not protect my right to criticize Tarrant County governmental action. At page 3 of your rules, the prohibited conduct includes personal attacks, impertinent or slanderous remarks. The problem is, what's impertinent? Is it impertinent for me, Judge O'Hare, to stand before you and say that the rules now before this court give you power to dismiss me from this meeting merely because I criticize you if that offends you? The specific part of the rule that is way too broad and gives you too much power says failure to comply with any part of the Commissioner's rules may result in sanctions, including but not limited to the following: removal from the court by the county judge or presiding officer, temporary prohibition from commenting in person during court. You have had people removed for a period of 6 months simply because they did something that displeased you. You can cancel the rest of my time should you find me offensive now, or you can refer me for civil sanctions or criminal charges as may be authorized under the code.
Thank you.
That's what's wrong with it.
So that's all the folks we have signed up to speak. Do we have any other comments from the court members?
So I think.
So just to clarify this, I get handed a stack of papers. I don't go through the papers, I don't sort through the papers, and I would only assume, but I don't know this because I've never checked, the stack of papers that I get is in the exact same order they are in. Some of you, okay, do not disrupt the meeting. Okay, so I would agree with people who have said, I signed up here and then this one signed up later. I would agree it should come in the order. Okay, I don't believe anyone has ever brought that to my attention. If they have, I certainly don't remember it. I've never heard anyone up here talk about it, but I'm in full agreement, and I don't think you have to put that necessarily in the policy. You can direct the staff, put it in the order. Whether you agree with it or you don't, part of the issue they run into is these things happen literally every meeting where they didn't get this one in the pile. I don't know why they didn't get it in the pile. I don't form the pile, nobody here forms the pile. I don't know why it didn't come through. Sometimes it's because people think they've signed up for a different item. Sometimes they sign up for public comment and they don't sign up for the specific agenda item. There is no effort from anyone here, me included, and there is no effort from county administration to pick some speaker and throw them out. So do they make mistakes? I'm sure they do, but there's not an intentional effort to stop you, sir, or you from talking. So if you'll tell me your names, I'll look and see if you signed up in the public comment portion.
CJ Grisham, Judge.
Okay.
Yeah, he's in speaker, non-agendized.
So we've got you down for speaker non-agendized, where it did not list the agenda item.
Yeah, I listed it for you on the form. On the online form.
So I see your form. It doesn't list, it says agenda item number 16. What is agenda item number 16? I'm asking our staff.
He's just open comments.
So here we get into that, not that anybody cares all this much about it, but so here's where we run into if the form wasn't filled out correctly, and then I say, okay, well, you can go. All right, well, then now I'm allowing somebody special privileges. And so I try to enforce it uniformly without regard to anything and make sure it's fair. Some of you brought up some things while they're looking. It gives me the power to throw you out if I don't like what you're saying. I've never done that ever. Don't plan to ever do that. I have removed people that didn't stop talking and they kept going forever. I did remove people that screamed and yelled, which I think you do, and try to scream and yell in any courtroom in America and you'll be removed also. I mean, it's just kind of how it goes. Do we know what agenda item number 16 is?
Judge, I'm looking, the only section I think where I see an agenda item 16 is under purchasing.
Okay.
Which would have been a consent item for cement slurry.
Okay, tell me your name. Yeah. So if you're in public comment, I'm not going to call you now. I see his form, and his form says agenda item number 16, subject matter jail deaths and TCSO bullying, violence, authoritarianism, and abuse of authority. Did you fill out more than one form?
I did not, Judge, but I'll just...
So I would tell you that this is not under that topic, so I'm not going to have you speak on that topic. All right, so those are the speakers we have. Comments from the court members?
Yes, I'd like to thank especially those with a legal background for stepping up and answering Commissioner Krause's question about which actions were violations of the First Amendment. And really prohibiting somebody from clapping is a violation. These people who come down here regularly have been so conditioned, if not trained, if not their minds enslaved to, last meeting I saw people clapping like this because they were too afraid to express themselves for fear of getting kicked out of their commissioner's court room. their building, talking to their elected officials. If clapping is an issue, we clap for nothing. Nothing. No proclamations, no Marine vets. My son is a Marine captain. We clap for nothing. One person of this court should not get to pick and choose what the forms of expression should be. And we do get the same stack. That is exactly how I know that he has taken speakers out of order.
I most certainly have not.
You absolutely have.
I most certainly have not.
Okay.
That's just
all right.
ridiculous.
That's
Find one.
fine.
Point to the public anyone I've ever done that with.
Do you remember the meeting after the meeting in which you told me to shut up? We had overflow.
I never told you to shut up.
We had
so that's another
overflow,
misstatement of facts, which that's all you spew when you talk.
Overflow rooms of people. And I was keeping up, and everybody that signed up in support of you got pushed to the front.
That's just
it was
so
madness
dishonest.
trying to
It's
keep
so
up.
sad.
So
ridiculous.
Yes, we get the same stack, so it's easy for me to keep up. It's easy for us to keep up. So thank you legal folks for coming up here to help answer the question about First Amendment violations. And thank you all for coming. Unfortunately, they're not going to listen. Several people have texted and asked, does this have a chance of being postponed? And I've been honest with you and texted you back to tell you no. These two gentlemen will follow right along with him. So.
Yeah, I'll say there were a lot of legal comments made today, but nothing that I heard alleged a specific violation of constitutional law. I know Ms. Cox talked about a designated public forum, but I know she's probably very aware that court after court has said, even in a designated public forum, there are reasonable time, place, and manner restrictions that an entity can put on to make sure that things go in a uniform manner and in a way that it needs to go. So again, I've not heard any allegation, any specific provision from the Constitution that has been violated by these, which is very important to me. You can laugh all you want, but until somebody points that out, we have that. So I appreciate y'all being here and expressing your viewpoint. I really do. So thank you for that.
All right, we have a motion and a second. Any other discussion? All right, please cast your vote. All right, it passes 3-2. Next, we get to item number 4, which is consideration of out-of-state travel requests.
Judge, I'm sorry to interrupt. One amendment we need to make on the travel policy due to the executive order that came out from the president yesterday with regards to putting a pause on federal funding. We have one item, the first item, the travel request to go to the housing assistance request. We're going to ask that be pulled from the agenda for consideration today. We've checked with budget, legal.
The very first item, housing assistance.
Yes, we would like to hold that item for now, please.
All right, so do we have a motion to approve the out-of-state travel requests listed excluding housing assistance?
Move approval.
All right, we have a motion to approve. Do we have a second? I'll second it. Any discussion? All right, please cast your vote. All right, passes unanimously. All right, now I believe we are adding D5 to the agenda, removed from consent. I removed this from consent for discussion, and I'll tell you why when I find it. So we just approved during the consent agenda an item that should make, we had a minimum that a court reporter could, an interpreter could bill. We just approved a change to that where we removed the minimum, and what it was doing was somebody might come show up for 15 minutes. in some instances would have been content with, yes, pay me for 15 minutes or 30 minutes, but we have a minimum of 2 hours, so we remove that. What number 5 is also involves court reporters, but we have 2 instances where I believe people were hired, if you will, or asked to come be court reporter interpreters in criminal courts, but it was canceled, and so they charged an 8-hour minimum, which I don't believe I've ever seen that before here. Now, we may have passed it before, may have looked at it before, but I don't think I've ever seen an 8-hour minimum. So my understanding is a judge can say, yes, I'll sign this, but ultimately the Commissioner's Court has approval. So is that an accurate understanding of the law? Do you know?
I do not know offhand, Judge. I can look it up and get you in the video.
Okay. So I believe the law does not give, in this instance, final approval to the judge who ordered you can pay the whole 8 hours. I don't know the specific circumstances of these 2 instances, but if this is a scenario where they were down at the courthouse at 9 a.m. for an 8 a.m. time to arrive, there was a plea bargain that went on, it took 2 hours, well, I certainly would say they should be paid for time. I don't know that I agree with 8 hours. If it's a scenario where they were called the day before at 4 p.m. and said, this thing resolved, we don't need you, to then turn around and get a bill for 8 hours, when it might not have even been 8 hours if it actually went forward, I just have a problem with that. I want to know, what does the court think? Do we just go ahead and say, here, pay the 8 hours? Once you do that, now every single time there's a cancellation and people catch wind, 8 hours, 8 hours, 8 hours, 8 hours. And that's $800 from my understanding on 2 different cases where they literally didn't come to work that day. Now fill me in, tell me what I got wrong or if I got anything wrong.
So in these 2 particular situations, I do not know if they showed up for any length of time. I would assume on these 2, normally the reason you don't see these is we contact the judge and the vendor to negotiate with them down so that we are not being billed. With the removal of this item from the policy, the interpreter fee policy, an agreement has been made between the auditor's office and the budget office. They will continue to send anything that has a minimum or a cancellation on it, amount on it, so that we can continue to work with those with those vendors and the judges. You're correct, the judge does sign it, but I do not know on these 2 particular situations if they showed up at all. I would assume yes.
Court
But
members,
yes,
any thoughts on this item? So if you vote to approve this, you're approving 2 people at this point, not knowing when they showed up or if they showed up. You're approving 2 people to receive $800 from the county, but I think also opening the door for that to happen again.
Now, Helen, I know that there's very unique and particular rules around court reporters and the
interpreters.
Or interpreters.
Did I say court reporters again? Yeah, I keep saying that. Sorry.
So, I mean, I guess explain to me if there's some nuance here, what authority we have to not pay and pay. Can we make the decision to say we don't know?
So y'all set the policy for the fee for indigent, and that policy right now, which is being amended in your packet, is $100 an hour. That's what you have approved. Anything that is outside that exception has to come back to y'all by statute for y'all to approve an exception to that fee policy. Am I wrong, Mark?
That is consistent with the policy.
So we set the fee, but we also have to approve payment.
Correct.
Because it keeps coming here to us to approve.
Right. And because this is their fee, they're saying that we want to be paid for this, but there's no avenue for us to pay for it without y'all's approval.
Okay, so here's another option. We could approve today all of them but those 2, and then go get some more information, find out what the law is if the court has an appetite to do that.
We can absolutely do that. We will reach out to the vendor and the judge On most occasions, we do reach out to the judge, and the judge is usually agrees to get with the vendor, re-sign an invoice, reducing that amount down.
Yeah, and let's just say, for example, that they were notified at noon the day before that this matter's been resolved. Okay, well, here's my 8-hour bill. I would just have a problem with that. So
Yeah.
I think we need to know more before we approve those two. So
Helen, I know this comes up occasionally. How big of a problem is this?
On the minimum or
on the minimum?
The minimum is usually every single court. There's one or two.
Right. Okay.
Yes.
But
There's always exceptions. Every single court, there's an exception to the interpreter fee policy.
Yes.
And this is presented under our section.
Okay.
all right, so I will make a motion to approve the payments listed in item D5, numbers 2 and 3, and to table items 1A and B until we have more information from staff.
Second.
All right, we have a motion, a second on that. Any discussion? All right, please cast your vote. All right, passes unanimously.
Thank you.
Thank you. Next, G1, we're holding until after close, but you wanted to make some comments on G1.
I do. So here we are again. We just discussed in last court the unfortunate death of Mason Yancey. And as the jail continues to cost families their loved ones, the cost grows higher and higher for you taxpayers. I said this would happen, and yeah, here we are again for another large sum of money for outside counsel. Now understand what this court communication is saying. The fiscal impact to date is $31,892.89 in Ms. Holly's defense. However, the law firm is to use all reasonable means to resolve this matter at an additional cost of no more than $35,000, not to exceed a total cost of $65,000. Hold on, subject to further court approval. So we've already spent $31,892 with just this one detention officer's case. If this court votes to approve this, this will be an additional $35,000 of taxpayer money spent. The cost of outside counsel is slowly climbing. In this case, just the Johnson case, to almost $500,000. And the court communication is not saying the price tag for this one detention officer's case will stop at $65,000. It's saying they can spend $65,000 of your hard-earned money before coming back and asking for more. And there will be more. I have questions for the DA. They probably want to take them in close, but why is Holly asking for more money? How many responses have been filed in the Holly case? And it looks like to me it was stayed. So in full detail, can you tell us, Mr. Cradaville, what occurred in the Holly case that leads to needing more funds? Now we've got to cough up more dollars for her defense, and so we need to understand what that is. And listen, it's not like a wrongdoing did not occur in the Johnson case. It's not like the cause and manner of death of Anthony Johnson in our jail is debatable. It's not debatable. It was wrong. And I personally think more detention officers should have gotten charged, because there are more people that did the same exact thing as Detention Officer Garcia. So ego is going to cost this county a mint. And I'm going to show you where we are right now. If my chief would come up here for a second. Let me show you where we are right now, just in the Johnson case. It's one case. August 6, 2024, agenda item F1, amount $30,000 for one defendant. Agenda item F2, $30,000 for one defendant. November 12, 2024, $100,000 for an outside law firm to defend the county. Also on November 12, 2024, agenda items D2 through D9. The amount was $30,000 each for 8 defendants. And I think my intern may have left one or two off, but right now we're at a total of $400,000. That's just for the Johnson case. We could have avoided spending this much money and more to come if we would have attempted mediation, utilizing attorneys from our district attorney's civil division with regard to the outside attorney representing the county, not the outside attorneys representing the detention officers. This money is money that could have gone toward a settlement because we will end up losing. We're giving away free money. And look, these firms are going to try to get as much money out of us as possible because they know that this is a case that should be settled. But we're dragging this thing out, hiring an expensive outside firm to defend us for a jail debt that our sheriff has been on TV saying this was wrong. And he fired 2 guys for it. So this does not make any sense. It makes no sense. So I'll go back and close and listen to what they have to say about why Ms. Holly, the detention officer Holly, needs additional funds. But just know, I'm going to bring my little thermometer every time the DA's office comes back to court seeking additional funds for each of these detention officers and for the expensive law firm that we've retained to defend the county in a case in which everybody in here saw on TV, on the news, we snuffed out the life of Anthony Johnson Jr. And you all do the math. I'll help you do the math with my little thermometer. But here we are again.
All right, we have 3 speakers signed up to speak on this item. The first is Nan Terry, Bishop Kirkland, Linda Hanray.
Good morning. Good morning, Mr. Krause and Mr. Miles. I haven't been here this year, so welcome. I'm Nan Terry. I'm here to speak on behalf of the item to discuss hiring an additional lawyer to defend the employee in the death of Anthony Johnson. I'm not against the idea of defending our employees as required, but I am against the idea of not settling. I want to use part of my 3 minutes to tell a story. My father is still living. He's 93. He was a member of the student editorial board of the Law Review at the University of Texas. He was in the top of his class. He was a corporate attorney for an oil company. When I was a kid, Dad promised we would run out of gas before we got gas from this other company. He swore it. The company names don't matter. Over time, the company's names changed with acquisitions and mergers. We still didn't buy their gas. Dad still has never bought their gas. Even after he quit driving when he rode with me, we didn't buy their gas. Why? Because that original company wouldn't settle a lawsuit even when that company was wrong. It wasn't just Dad. I had the opportunity to meet with Dad and a couple of his law school buddies. They denounced many things, as you can imagine, but one was the clogged courtrooms where parties should settle instead of litigate. It's a gamble whether the county has culpability. In the last election, according to the county's election data, 46% of the voters did not vote for the county sheriff who was in charge when Anthony Johnson died. Facts. Tarrant County has a history of deaths in the jail. I'm here today because the county led the state in deaths in 2020 and never acknowledged that dubious distinction. The only cause of death in this case is homicide. The district attorney has dismissed charges against other jailers, against a jailer related to the beating of Corey Rodriguez, yet that same DA has filed murder charges in this case. And you're refusing to settle? It's a gamble I, as a taxpayer, don't like. We will all pay for this. What message are you sending companies who want to do business here? That we don't settle? We should acknowledge our faults, make changes, settle the case, and move on. What message are you sending? Thank you.
Following Bishop Kirkland, Linda Hanratty.
Ms. Hollis, a civil servant, you know as well as I do, we have to pay. I contend that Ms. Holly is a small fish. We don't need to worry ourselves with small fish. We need to get rid of the big fish, our sheriff. The criminal district attorney's office is requesting an additional $35K. The current sheriff is a real issue. You people are getting into a pissing contest with the Johnson family. It's not wise. They have suffered enough. The condescendingly appalling presentation that the sheriff, the JPS, and behavior people gave 2 weeks ago is laughable. Laughable. No, Mr. and Ms. Johnson, your son's death is not laughable by any standpoint. What is laughable is that if the wheel was as well greased as those people presented to us, Anthony would not be dead. I desperately want this action to find its way into a courtroom. I want to see this video. I want the world to see this video. The question that yearns an answer: how in a civilized culture can this degree of brutality and suffering exist? Why does Tarrant County previously, continuously, and blindly write these checks for a fragmented, dysfunctional sheriff? For me, it's inconceivable. Take the key back from the fox, and the hens will be all right. I'm tired of hearing this court say that we have no jurisdiction over an elected official. The Local Government Code 87, Section 87.001 states that a district judge can remove a county judge, commissioners, district attorneys, sheriffs, and so on. With approval of this action for employee Holly, we will continue pour money into an empty pocket, into a pocket with no holes in it. When does the buck stop? Better yet, when does this county stops and recognizes what we've done to veteran Marine Anthony Johnson and just simply say, we were wrong. Mr. and Ms. Johnson, we apologize. And Mr. Johnson, if none of them will, I apologize for what we did to your son.
Ms. Hanratty.
I thank the other speakers, especially Alyssa Simmons, for the money. I counted more money than that.
Yeah.
I counted because I did a little Excel spreadsheet when we started doing this, and my number comes up to, with the latest for Holly, it comes up to $585,000. Now, did she do something special that she needs more money? or are all of them going to need it? And that's 14 more people. And I figured out, because I like numbers, that if we gave them each another $35,000, that's another $490,000. Please settle this case so county taxpayers like me, who live in Precinct 4, are not saddled with more legal expenses. $1 million here, $1 million there, pretty soon it adds up. Thank you.
All right, that's item G1. Now and we'll receive legal advice and discuss the litigation in executive session and then come back out here and take action if there's action to be taken after closed. Next, we go to G2, which is pulled from consent, which is consideration of a settlement agreement in a suit filed against Tarrant County by Gregory Cater. I'll move to approve that.
Second.
We have a second. Any discussion before speaker? Bishop Kirkland.
I do first.
Okay.
You want
All right, we have a motion to second. Any other discussion or any discussion at all on this item? All right, seeing none, please cast your vote. All right, passes unanimously. Now we go to K1, which is from consent, juvenile services. Who is here on behalf of juvenile services? Okay, come up, would you come forward? And this may not, Ron, necessarily be your question, but you can address some of it. So, when is this particular contract that we enter into with Fort Worth ISD?
Yes.
How long does this contract run for? Is it a one-year contract?
Yes, sir.
Okay, and we would be approving the contract now.
Is this the juvenile justice or the detention contract?
Juvenile justice.
Juvenile justice alternative.
Yes.
Yes.
That's an annual contract.
Okay, and like it's to approve now to go for a year?
Yes, sir.
Okay. We described, like, we don't pay the city of Fort Worth to do this. I'm sorry, I said city of Fort Worth, the school district. Do they just get funding per pupil from the state, or do we actually pay them?
State funding, sir.
Okay. Have we opened that up at any point in the last 20 years to any other school district?
No, sir.
If we were to do such a thing, A, can you legally do this? B, how would you do it? Is it an RFP? And that may not be your, if you know, you say, yeah.
I don't know, sir.
So I'm not here to bag on Fort Worth ISD. I know what I've seen, heard, and people have talked about, and the scores are failing. Why they are, I don't know. I'm not an educator. I don't pretend to know. But shouldn't the question be asked, are we doing a disservice to these kids if we don't look at other options?
No.
Sir?
The reason I think we do it with Fort Worth ISD, our location in Leland Pope is in Fort Worth ISD School District.
Are these teachers that teach the kids there full-time teachers, or do they just come in for an hour here? Is it's run basically like a regular school?
It is. It's alternative school that's required by standards, so it's statutory. A county over 250,000 people has to have an alternative school run by juvenile justice.
Okay. So, this is for Helen, Chandler, Ron. Can anyone tell us the last time we looked at if another school district would be more appropriate? Or do we just do this every year, go through the motions?
I can.
Okay.
In the 33 years I've been here, we've always contracted with Fort Worth ISD.
Okay. I think this is going to pass today, but let's say that it did not pass today. What then happens? They are without a school for 1 year. Okay.
They will be without teachers.
Which obviously we're not going to do that, and this is not something to scramble around at the last minute. I wanted to bring up the subject so to get it on people's minds and to potentially look at the next time it rolls around. Maybe they do a wonderful job at this, and teaching is difficult by itself anyway, and I'm sure this one is even more challenging. Do we owe it to these kids in the school to go look at other options and see if there's a better way to do it? And we may look at this over the next 6 months and determine the answer is no, but there seems to be so much turmoil out of there all the time. I want to make sure we're giving the best education we can, and so that's why I brought up the subject and why I pulled it from consent. Any thoughts, comments? Fire away.
Well, Judge, I'll say this. So I sit on the state juvenile justice department, the state agencies board, and the state is the one that funds that. So like you said, it's statutory. I'm not sure the statutory requirement for district. I mean, it may be if it's within that district, then there's no choice. But I will say there are actually block grants that are available from the state, and I've already spoken to our juvenile probation chief, Riley Shaw, about creative programs, out in the community, home-based programs, et cetera, that Tarrant County can apply for specifically so that we're reducing recidivism, providing a better education, all the rest. I've said, listen, throw everything that you can think of at the wall, and if there's a way to get the state to fund it, we'll make it happen. So I think we'll figure it out by statute what they have to do, but it's going to be a state change or a state solution, I think. This may just be we have to pass through approve it. I'm not sure.
Yeah. Mark, can you just give us a legal memo just on what the law says about it? Again, we're not going to leave the kids without teachers today, or I can't imagine, but it's something I think we ought to at least explore, to look at, is there a better way to do it? Is there a better group to do it with? And the answer may be no. These people may do phenomenal at this. I don't know. But after 33 years, we at least owe it to check into it.
Well, I'll say this, when it comes to education, and I'll be bringing forward a resolution in the next couple of meetings that touches on literacy and the importance of literacy in a community. I had our folks do a little bit of research in crime rates and folks getting arrested or kids getting arrested. Almost 95% of them are not able to read at grade level, by the time they're in third grade or whatever the stat is. So, I mean, that's a huge issue in education. I mean, education truly can save lives and change the course of somebody's life.
That's Hope Farm knows that. That's why reading is the most important thing they work on. And Academy 4, which is a local nonprofit started by...
My wife's volunteered for that, man.
That's wrong, yeah. The gentleman, a very wealthy, brilliant businessman that started that, we have had discussions with him, both Riley Shaw, Judge Kim, myself, about what programs they could put together to help in this very scenario and with that group. So okay.
I had something. In addition to the legal letter, if we could get some metrics, how has the program operated over those 33 years? Successes, failures, that type of thing.
That's a great point, because, I mean, we're currently in legislative session. So if we are barred, we're stuck in a program by the statute, that's something that we could potentially ask the legislature to say, hey, give locals the ability to be flexible, to add options.
I think one thing that'll be probably a little bit difficult to come by when it comes to statistics is some of these kids are here a very, very short time, so they don't measure them from 1 year to the next. Now, if this school does, and then the school they go back to does, I mean, it's possible to put it together, but it wouldn't be the easiest thing in the world to come up with, like it is just general statistics from a elementary, junior high, or high school, middle school these days.
Is that true?
That is true. We do have outcome measures. The TJJD and prior to that, TJPC, the Texas Juvenile Probation Commission, has recognized our juvenile justice alternative school as a model for the
state. We often have other districts come visit us, see what we're doing. Our audits have been outstanding throughout the years. I don't think we've got less than 100% rating on any of our audits in the last 12 years. A lot of work, and the campus is different. Classes are smaller, our students are getting a lot of attention. We provide a lot of resources, life skills program. It's just not about the education. We work with families there, provide them resources if needed, but I think it is a model for the state of Texas right now, and I'm proud of that program.
Okay. All right, any other questions or comments on this item, or do we have a motion?
Move for approval.
Second.
All right, we have a motion and a second to approve. Any discussion? All right, please cast your vote. All right, passes unanimously. Thank you, Ron. All right. All right, now we come to purchasing. Items N1 through N8. Does anyone have any questions on any of those items for Melissa?
Move for approval of items N1 through N8.
Second. All right, we have a motion and a second to approve purchasing items N1 through 8. Any discussion?
Judge, I signed up to speak on that.
Thank you for catching that. I don't have that. Did you sign up for public comments, or did you sign up for that agenda item?
I entered N17 on the online form.
Okay.
Was N17 passed in consent?
Yeah, it was passed in consent.
Is he saying in?
So
Yes, in N17.
Probably no one is interested in hearing this really, but just one of the things that the change is trying to do is avoid this kind of stuff. And we have this literally just about every meeting where something didn't get in. I think there's a way to do the forms different where if you want to speak on 4 items, you don't necessarily have to speak 17 different times. So can somebody find his form? Which item are we talking about here? In one of the purchasing items?
17.
Is he also?
What?
Is he back in Parker?
No.
Palmer.
No.
Joe Palmer.
So have we?
Oh, yeah,
so,
look.
okay, we found it. So, okay. Got it. You are welcome to come speak on this item because we did not call you previously. However, this is not, we have already passed N17 through the consent. What should have happened there was, we should have been notified that we have a speaker on consent, it gets removed from consent, which is what just happened on one of those, G2, I believe.
So it's passed out of order.
What now?
It's passed out of order, it sounds like.
No, it was passed as part of the consent agenda. It just, they didn't, anytime that there's a speaker on a consent item, we're notified to pull that item.
Okay.
So they can speak before we vote on it, and we weren't, nobody
Didn't happen. I don't think it was
Yeah.
intentional.
No.
No.
But
I
if
think-
you would like to speak on that, go ahead.
Sure. Yeah, so this is a good enough time as any. I've got some copies here of a letter from the Texas Commission on Jail Standards. The letter is addressed, Dear Sheriff, and this went out July 24th, 2017, following the Sandra Bland Act, passage of that act. I assume that every sheriff in the state got it, times 254, and I'd like to hand this to somebody.
Hand it to
give each
him.
of you a copy. Thank you. Just, So the reason I wanted to speak on this item regarding the Sandra Bland Act is that I believe that, so N17 is to purchase tactical gear for the Sheriff's Department. I would like to appeal to the Commissioner's Court to look very, I don't have an agenda packet. I don't know what each of the line items are, what he's asking for. Do we want our deputies to be safe? Yes. But I would propose to make an amendment to this item to divert some of the funds to necessary improvements in the jail. Your jail is understaffed. Your jail is out of compliance. So there are things called variances, and that's listed, that's not listed in that. We have variances. We have a list of variances. Some of the highlights are that the main jail is more than 30% over capacity. And that is a lifetime variance. So legalese, you could say that when you have a variance, that makes you in compliance, right? That lets you operate out of bounds. Do you have to do any more than the absolute minimum, what the state requires you? I suppose legally you do not, financially you do not, but I would appeal to you that it's important for you to go beyond, and I don't expect you to negate the variance. There are at least a dozen variances. The water lines are, one second. Green Bay has a variance issued in 1996 for a medical isolation cell that is shorter than the minimum required height. Jail standards require at least 8 feet, and this cell is 7'9". This variance has no expiration. Belknap has a variance issued in 1977 for an unknown number of cells that do not have an associated day room. You also have a variance relating to adequate lighting in the mental housing area. Let's just focus on that. Number 10, Belknap has a variance issued in 1988 for lighting requirements that are not met in the mental housing area. The jail standards have several lighting requirements. So what would it cost to improve the lighting, to bring lighting up to state standards in the mental facility? Would that cost, $10,000, $100,000 out of whatever is being asked for in the tactical gear?
Thank you.
Thank you.
Thank you.
Thank you. All right, so Mr. Crowderville, in light of the fact that we had a public speaker for an item that was not called, do we need to address N17 in any way, shape, or form?
It would be advisable, Judge. What I would recommend is if the court would like to reconsider approval of the consent agenda, pass it again as amended with N17 removed, and then pass N17 individually.
Well, couldn't we just make a motion to readdress N17 by itself?
I think we could defend that.
Okay. So
a motion to reconsider items
and
in 17.
Mr. Palmer, our apologies that we missed it.
Were you going to make a motion, Mr. Kraus?
Yeah, I'm happy to make that motion once we're settled on it.
Yeah, go ahead. So,
motion to reconsider item N17 from the consent agenda.
Second.
Right. We have a motion and a second. Any discussion? Please cast your vote. All right, passes unanimously. Now,
a motion to approve N17.
Second.
Okay, we have a motion and a second to approve N17. Any discussion there? All right, seeing none, please cast your vote. All right, passes unanimously. All right, now, I believe we had a motion and a second on the floor to approve N1 through 8. Has that in any way, shape, or form been deemed removed, or is that motion and second still good? Okay. All right, we have a motion and a second to approve item N1 through 8. Any discussion there? All right, please cast your vote. All right, that passes unanimously, which then brings us to N9, and I have one issue with N9, and that is I. So, with our new HR director, do we not have the ability to do our own compensation study? And when we previously did this every year, a side-by-side comparison of the two presentations literally had a handful of changes to the PowerPoint. And I don't know how the rest of the court members felt that were here. Certainly don't know how the two that are new would view this. But it seemed to me like the compensation study was a gargantuan waste of money. Okay.
I don't disagree. What I'm asking for this time is something very, very different. We need to look at our current actual structure We need to revisit job descriptions, leveling requirements. We need to get alignment on that. The structure itself is based on market comp data and the way that it's leveled. We need to revisit the foundation of compensation. And so this particular request is really going to address all of those items. In addition to that, we need to be looking at the FLSA classification for each of our jobs, because that also comes into play around compensation. I also, and Judge O'Hara, specifically to address what's happened in the past, in addition to looking at structure, I also want a tool that allows me in real time to look at comp. So when we have a new position, we can actually plug that into our current salary grades, not current future state. We don't currently have that. I have showed Helen and Kim and some of my internal staff what that looks like. We don't have anything like that today. So we need better tools, then we can address current structure.
So if I could shrink that down into its most basic form, this is not a repeat of the same old compensation study that we throw a check for 50 grand for and get basically a flyer back that says the same thing as it did last year.
Exactly.
Okay.
Lots more detail.
Okay. All right. Do we have a motion or any questions on item N9?
Move for approval.
All right. We have a motion.
Second.
And a second on item N9. Any further discussion? All right. Please cast your vote. Passes unanimously. Now brings us to N29 from consent, purchasing policy revisions. Y'all can blame me for this one also. Reading through this, what I found, the request is to ask someone to be designated. I think it's you, Melissa.
Yes.
To be designated
to accept
someone the Commissioner Court is delegating authority to do things in the event of an emergency case.
Yes.
But then there's never a definition that I found of emergency case. So who determines when it's an emergency case?
There is a definition in the policies and procedure, and it's regarding public safety or additional property damage.
Can you read that for me?
Yes.
I don't know how I missed that. I mean, if it's like a page long, I don't want you to read it. Do you have it pulled up?
I'm about to.
So the emergency condition is described in 262024A1, and we have a section that addresses in our policies and procedures emergency purchases, which could
What's the?
they're defined. I'm sorry.
What's the
item number?
Yeah.
14 dot what?
The item in the policy and procedures?
Yes. Where does it define emergency?
.33.
9.33?
Yeah, it's in here several times. Emergencies.
I don't see 9. Looks like it starts at 14.
Starts at 14.
Yeah, I don't think anything that we got in our packet has 9 point anything in it.
No, it's not. So what I'm addressing here is under construction, payments and performance bonds.
Okay.
So normally we bring payment and performance bonds for annual contracts that are less than $50,000. Most of them are
And it's
just,
designating you as the emergency person, and what is an emergency?
so an example of things that have.
I don't want an example, I want to know exactly what it says.
Is that 14.14 payment bonds? Where's the emergency?
Unless I am misreading this, what is being asked is for the Commissioners Court to give away a power to a member of the staff, an authority, a legal authority to a member of the staff, and we don't know under what scenario it gets triggered. What, is it when you deem it an emergency, she deems an emergency? Who deems emergency?
The department or the, here?
27.
In emergency cases, this says section 262.032, in emergency cases, the Commissioners Court may delegate the authority for the acceptance of bonds, including performance payments bonds, to the purchasing agent. Okay, so this is, we're designating her now, but we will have to vote again to designate her an emergency. Can anybody answer this?
So these are items under $50,000, which are not required by law. So what triggers a payment bond is $25,000. So there have been cases where HVAC, most of those, there have been minor repairs. We have annual contracts for HVAC repairs. And so when a vendor comes out to make that immediate repair, and it's under $25,000 just to get the system back online, those are under annual contracts, which
Okay,
are
but I think the whole question, who decides when there's an emergency or what it is, or how this process works, sitting here, we still don't have an answer. So if we do not pass this today, we table this, can y'all get these answers before we vote on it?
Yes.
Okay.
And would it be, so in that example, HVAC, would it be the facilities director?
Yes.
Says, hey, this went down overnight.
With
You're
my
the purchasing
approval,
agent,
yes. And anything over $50,000, we've always bought it before
Yeah,
court.
I'm not opposed to the idea that we designate it. I just want to know who decides when it's an emergency and who gets to call it that. I mean, I think that's just good governance.
I think the answer is department heads or elected officials who are in charge of.
So any purchases under $50,000, I'm the designee. Anything over $50,000 by law has to be approved by Commissioners Court.
Yeah, we know that part.
Okay.
His question is, who determines the emergency? So would it be the tax assessor if something happened in his operation? Who determines?
Yes, so the end user will have an urgent issue. They would bring it before purchasing, and we would find out all the details. If it's something that cannot wait, we'll tell them to go ahead and move forward with the purchase. And we will, if we see that it's going to be over $50,000, we will
bring it to court.
Have to bring it to court.
But if it's $49,000, somebody says it's an emergency, we just get to go do it, and we don't even see it. So I would feel more comfortable, y'all can make a motion, vote however you want. I would feel more comfortable if we brought this back and had a little more understanding of what exactly it does and what triggers it and who decides it. That would be my preference.
I move approval.
Yeah, I'll second.
Okay, we have a motion and a second to approve.
I thought you were motioning to table.
No.
She was motioning to approve.
Oh, okay. I rescind my second.
Okay, we have a motion to approve. Do we have a second? Okay, so it dies due to lack of second. So instead of making a motion to table, just brief us on it, bring it back, tell us, give us those answers, put it on the next agenda.
Okay, thank you.
Thank you. All right, that's N29, I believe it was.
Yep.
From consent, we're through purchasing. All right, now we move to transportation. Consider establishing a speed limit of 25 miles per hour in the South Fork Estates subdivision, phases 1, 2, 3, and 4 in precinct 1. That was the earlier, I think it was the second public hearing, but it was one of the public hearings. Do we have a motion?
Move approval.
Second.
All right, we have a motion and a second to approve that speed limit. Any discussion? All right, please cast your vote. All right, that passes unanimously. Next up, item Q2, consider establishing a speed limit of 35 miles per hour on Timberview Drive, which was one of the previous hearings. Do we have a motion there?
Move approval.
Second.
We have a motion and a second to approve that speed limit. Any discussion? All right, please cast your vote. All right, passes unanimously. Next, we have board and commission appointments. Do we have any board or commission appointments? All right, seeing none, we now move to approval of bonds and certificates of self-insurance. I'll move to approve the self-insurance in lieu of a bond of $2,500 for Kenneth Wilson from the Tarrant County Fire Marshal.
Second.
We have a motion and a second on this item. Any discussion? All right, please cast your vote. Passes unanimously. Are there any other bonds or self-insurance things to vote on?
No, sir.
Okay. Brings us to a briefing item, briefing on education code, sections 13101 through 13105.
Afternoon, members of the court. Mark Radville at the DA's office in Civil Division. I've been asked today to come and talk to the court a little bit about certain aspects of the education code. Before I get too deep into this, I just want to preface this by saying I'm a little constrained in what I can say. I'll have to stick to precisely what the statutes say and not get into any opinions or advice to the court in an open session. So there are 5 statutes that are agendized for this briefing item. They're Education Code 13.101 through .105. And these sections have to do with the process of detachment of a school district. This is a process that essentially allows a single school district to split into 2 and create a brand new school district where one did not previously exist. There are 2 methods, really 3, but 2 primary ones where detachment can occur. The first is the route of a petition where a group of 10% of the registered voters in the proposed detached area sign a petition, bring it to the Commissioner's Court, and then in 30 days the Commissioner's Court holds a hearing on the validity of the petition. If the petition is deemed to be valid by the Commissioner's Court, then the school board orders an election. The results of that election are then brought back here, and if it passes, the Commissioner's Court orders the creation of the new district. That part is fairly straightforward. There's a considerable amount of detail in these statutes about what that election looks like and what the petition looks like. The second method is a little less clear. That is the resolution method. And there is some controversy over whether a resolution by itself passed by a school board initiates the process of detachment, or whether instead the resolution triggers an election similar in the manner that a petition does. And the statutes are not a picture of clarity on this front. If you just look at the straight language of the statutes, it seems to indicate that a resolution by itself is sufficient. However, there's a contrasting school of thought that says it triggers an election. There is very little to no guidance in Texas law as to which one of these processes controls. It is an issue of first impression. From our research, we cannot find a situation where this has previously occurred in Texas. I will tell the court that I've gone so far as to go back to the 1995 legislative session when the bill that created this session was passed, and listened to a considerable amount of the Committee on Education's hearings when they considered this. This item is not brought up. So we are...
so there's no spoken legislative history?
Not that I have heard thus far, Judge. And I'll be frank with you and tell you I've gotten maybe about halfway through what I can. I've started using AI to transcribe these hearings and looking through them, and so far no luck. So it's not particularly helpful, unfortunately.
Are we consulting with, which state agency are you obtaining guidance from? The AG's office or anybody?
Commissioner, at this point, we have not sought out any advice from a state agency. We've kicked it around pretty thoroughly internally. We've discussed it a lot. As I said, I've done a considerable amount of research into this. If there's anyone in particular that you would like me to reach out to, I'm happy to do that. I'm happy to hear any opinions or receive any guidance on this front as this issue continues to metastasize and could become something for the court to consider in the near future. So if you've got somebody, I'm happy to talk to you about that.
So are we in receipt of a petition yet?
Thus far, this court has received neither a petition nor a resolution. That could change at some point in the near future.
Okay.
Do you feel comfortable opining on if a resolution does get passed and it comes, whether it comes to the court with an election or not, kind of your reading of the statutes, whether that would trigger an election, or if it's just the resolution passes and then it goes to the commissioner's court, or is the law still too murky for you to feel confident saying one way or the other, kind of where you think the statute reads?
Well, I would say that's something we should discuss in executive session under advice of counsel, because there's so many variables that go into that. It would be me applying facts of the law and analysis there.
What you told us last week or 2 weeks ago in executive session, have you run across anything that's changed the way you view this?
No, Judge.
Okay.
I'd certainly say there's been some refining of that opinion, but the advice this court received previously still stands.
Okay. I wanted this agendized, as you are aware, just so we are transparent, and so we don't fall in the same situation that Keller ISD did initially, where they were doing things behind closed doors. So I appreciate you giving us what you got so far. I've heard from many constituents, and I believe the only fair way for Keller ISD to move forward is to petition for a vote. That's my position. And petition seems to be the predominant mention of this education code, and constituents have questioned the transparency of this process. So I think to deny citizens the opportunity to decide the fate of their kids through election only furthers distrust and suspicion that agendas are at play without consideration of all families and all students. So that's my position on it, and I would hope that this court would agree that, we bring this out in open so folks can hear that we're talking about. We're not trying to hide anything. We don't know, and so our counsel is telling you he's trying to get to the bottom of it for us. So once we're educated, you'll be educated about what our role is as a court.
And Commissioner, thank you for saying that. And one thing I would add, just to put a coda on that, is there are some portions of these statutes that talk about mandatory duties of the Commissioner's Court, such as splitting up the debt, issuing an order to create the district. If there is a detached new school district created, the Commissioner's Court appoints board members for the new district. Those are shells. The court has no discretion in it. You must do that at some point. The question right now is, what is the route that we take to get there? And I think it is important to note as well, one of the reasons that going into executive session to receive legal advice on this issue is appropriate is it's entirely possible that the county could find itself in the middle of litigation on this issue in the near future.
Sure. Thank you, sir.
Absolutely.
Question, Mr. Cradaville. So just so I can make sure I'm understanding what you're saying, even if this goes to a vote, this residents of Keller, for the detachment, we are still obligated to split the debt and appoint the board members, the new school board members. Is that accurate?
Correct, Commissioner. If the vote is successful in the detachment process, if the court receives a petition, the vote succeeds, the court shall create the new district, split the debt, and then appoint new board members.
Okay, just wanted to make sure.
It is a ministerial duty.
I think for us, I say us because I think we share an opinion. I think parents deserve that ultimate choice. I mean, they choose where they reside, which district in which they reside, which schools their children go to, how to hold their ISD boards accountable. It's for me, common sense, and if you can't find specifics in the law, well, you can't just make it up out of whole cloth.
Right.
That's just my opinion. Then again, we haven't got a petition or a resolution to trigger anything.
Yeah.
So, but that's my opinion.
All right, anything else for Mr. Cradaville?
Thank you.
All right, we have 4 speakers signed up to speak on this. Elizabeth Midius, if I'm saying that correctly. Following Elizabeth will be Barbara Brewer.
Could I just ask real quickly, with all the confusion in the beginning of the meeting, do I have 1 minute, 2 minutes, 3 minutes?
3 minutes.
Okay, this happens a lot at our board meetings, so. Okay, thank you for allowing me to speak today. My name is Elizabeth Midius, born and raised in North Texas. I graduated Texas A&M with a degree in aerospace engineering. And after a short foray abroad, got into Texas, back here as quick as I could, and dove straight into teaching math, science, and engineering courses in local high schools. 2 years in Fort Worth ISD, 9 years for Northwest ISD, and most recently 5 years for Central High School and Keller ISD. My husband Marcus and I owned a home in Azle for 5 years before moving to North Fort Worth to shorten our work commutes and have 2 kids. Our 9-year-old daughter has flourished at Ridgeview Elementary, and our 4-year-old son will soon. I only mention all of this to show you that we are deeply invested in our community. The difficulties and stresses our state's educators face daily are well known, but the connections and the hope I have for our future as a result of working with these young minds for the last 16 years is why I am here today. As you are well aware by now, Keller ISD School Board has demonstrated they wish to split the district. Over 33,000 of these young minds stand to either gain or lose immensely in this decision. Our school board has alluded they will not seek a public vote on the split. We believe they will try to exploit a loophole in the law and proceed without legitimate public input and transparency about how it will affect our students, teachers, staff, debt, and split of facilities. At the January 16th school board meeting, 120 stakeholders of our community signed up to address the board. Many of us were forced to wait outside in the freezing cold for our turn to speak, some with small children. Out of these 120 people, 118 spoke up either against the split or demanding the community be allowed to vote on it. Only 2 people spoke otherwise. These speakers, many of them nervous first-time attendees to a school board meeting, were from all over the district, from all demographics, and self-identified as being from all over the political spectrum. As divisive as politics are, there was overwhelmingly no public support for doing this without allowing us to vote on it. I want to personally thank Commissioner Manny Ramirez for releasing a statement early on, breaking it down by the book, and with a side of ethics, no less. It's refreshing to hear a voice of reason in the midst of this. I am here to ask all of you, on the behalf of all of the stakeholders of 76244, 76137, 76248, 76148, 76262, 76034, 76092, 76131, and 76182, speak up for us. Continue to speak up for us. Please pay attention to our next school board meeting this Thursday. If their plan moves on forward without a public vote, it will likely result in a domino effect to other school districts whose board members seek to maintain control at all costs. We have a right to be governed by the people and ask that all of you do everything in your power to ensure that the citizens in the school district are allowed to exercise their right to vote on such a crucially important issue. Our future literally depends on it. Thank you for your time.
Thank you.
Thank you.
Is Ms. Brewer present? Following Ms. Brewer, we have Matthew Mucker.
Hi, my name is Barbara Brewer. I'm a 30-year resident of Keller ISD. My parents were part of the original that lived in Fort Worth, paid Keller ISD taxes. We've been voters of Keller ISD for over 30 years. But I think it's very odd that we have a small group who decided to take our voices away. They needed our voice last year when they couldn't even get the vote they needed. That's right, 7% voted in that Keller ISD. They needed 76244. They needed 76137. They needed our voice to get on that board. As soon as they got on the board, they silenced us. And now they're taking our district away. I think this is a violation of... The fact is that, Matt, you own property in Keller. You're a Keller ISD voter. I mean, don't you think that's an issue? You're sitting here voting on this? I mean, of course you don't have a problem. Judge O'Hara,
We're not voting. We're not voting.
Just one
on
clarification,
I know,
we're not
but you
voting
made,
on
Matt
this.
Krause, you made it very clear that with a resolution, they could pass it. It needs to be up for a vote. We have a voice too. We've been paying taxes for over 30 years. And it's not fair. We helped to build that stadium. We helped build the K-Cow. We're gonna lose that. They say we're gonna share it. They can't even share the stadium as it is. Timber Creek hasn't had a homecoming game at the Keller High Stadium in 7 years. They talk about fairness, but it's not. There's more issues than that. Some people can't even get into the K-Cow that's on the other side of the tracks. This isn't an issue. But you know what's surprising is hearing all the different things about you, O'Hara, like the fact that you make it a us versus them. Yeah, Judge Whitley. And you know, it's not surprising that you're used to probably violating things. I mean, look at Farmers Branch. They had $1 million lawsuits because of your things that you passed. Like, it's just ridiculous. I'm just saying that I'm fighting for Sub 6244. We need a voice. And I think that this needs to move to a different county. It shouldn't be judged here in this commissioner's court. It's too controlled.
Following Mr. Mucker, we have Denise Allen Carson.
Didn't mean to do that. Members of the court, Section 13.104 of the Texas Education Code has sufficient ambiguity that there are those who would argue that a simple 4-member majority of a school board has the authority to create a new taxing entity responsible for up to 1/3 of the property owner's taxes without a general referendum by those subject to that taxing authority. I am fearful of how this section of the law might be abused by this misinterpretation. School districts across the state are currently facing crisis budget shortfalls due to inaction by the Texas State Legislature, and they are looking for solutions, any solutions, to their problems. If these school boards determine that they can simply cast off undesirable or expensive parts of the school district and make these parts of the district somebody else's problem and can do so with no oversight by the voters, what does the future of Texas public education look like? Worse yet, what might future school board elections look like? Vote for me, and I don't kick the poor people out of our school district. Vote for me, and I don't kick the black people
please
out of
lower
our
your
school
voice.
district.
Please lower your voice.
Vote for
Keep
me,
your comments.
and we will kick out Mr. Ramirez's people from our school district. And we can do this. We don't need a petition of 10% of the voters. We don't even need to take this to a general election. We can do this with a simple majority of 4 school board members. Put me and my 3 co-conspirators on the school board, and the 4 of us can make this a reality for you. We can do this because, as we all know, the rich white people vote in school board elections, and the poor people, and the black people, and Mr. Ramirez's people do not vote in school board elections. His people, in fact, are among the lowest represented demographic of any in the U.S. electorate. Vote for me, good people of future rich white school district. Together, we can dismantle Brown v. Board of Education, and we can bring back separate but equal to the great state of Texas. Should this issue come before the court, and should this court subscribe to what I clearly believe is a deeply flawed interpretation of the law, that little vignette is the reality that you will be creating for the state of Texas. If you don't think that there are school boards right now plotting to carve their districts along socioeconomic borders, there are thousands of parents in North Fort Worth that would like to have a word with you. I bring these words to you today so that you can reflect on whether it is really the intent of the legislature to give the profound power of creating a new taxing authority to a simple majority of 4 school board members, and that you can receive the wise counsel of others so that should this issue come before you, you can vote wisely.
Ms. Carson.
Good afternoon. My name is Denise, and I've never been here before, and I don't know if I want to come again. But that's okay. I'm a very concerned citizen, and my heart is breaking for our community. Just so you know a little bit about me, unlike the three people who spoke before me, I'm on the east side of the tracks. I'm in the, white, affluent, however, the rich people, whatever you want to call us. I have 18 years in Keller ISD. I have a master's of education. I also taught in Keller High School for many years. But my heart is really breaking for our community. This is a community concern. It truly is. And we've gone from this side, that side, to this side, and it's a cultural war, it's a socioeconomic war. But I'd briefly like to make a few points for your consideration. Number one, the potential violation of the Open Meetings Act, which we believe has occurred within our school board. Number two, the board members do not represent culturally, socioeconomically, or demographically the population of Keller ISD. And number three, the board members have stacked the board based on their own cultural and ideological beliefs, many of whom I associate with myself, but they've included appointing 2 board members without a vote, therefore stacking them on their side. The first one, for example, regarding the potential violations of the Open Meetings Act, there are at least 2 instances that need to be investigated. December 19th, 2 board members were presented a plan about splitting the district that obviously had been discussed without them. They were blindsided. And regarding the demographics, currently there are roughly 35,000 students in Keller ISD across 9 cities that you represent. This demographic of Keller ISD is not represented by the board. 59% of the student population is white, 11% black, 17% Hispanic. I could go on. But the Keller ISD board splits in a way that we believe they're going to split. Approximately 70% of the students will attend will be white, including a higher socioeconomic income level as well. The school board is represented by 7 individuals who are all white members. 3 of the school board members appointed 2 additional members without a vote. Clearly, the board has been stacked. I come to you imploring that you do your due diligence and uphold your position to enforce the rules of democracy. Democracy, by definition, is a system of government in which laws, policies, leadership, and major undertaking are decided by the people. I believe that what Keller ISD is going through currently is a major undertaking where we have a right to vote. Is Keller ISD and potentially the Commissioners Board circumventing the law with a supposed loophole, or are you going to allow the people their fundamental right to democracy?
Thank you.
Thank you.
All right, now we come to public comments.
I need clarification from Mr. Cradaville. I thought, looking at my notes, who calls an election? Is it the Commissioners Court? It's not the school board, correct?
So, Commissioner, that's a good question. If we look at 13.104, the Commissioners Court holds a hearing on the validity of the petition, and if the Commissioners Court determines the petition is valid, each Board of Trustees shall order an election to be held. So the Commissioners Court determines the validity of the petition, then pursuant to this statute, the actual election is ordered by the school board. So the language there assumes that there's multiple Board of Trustees, so you could have the school district that straddles counties. Obviously, that's not the situation in what we're talking about, but the school board is the one that ultimately orders the election, but it cannot do so until the Commissioners Court determines the validity of the petition. What is slightly confusing is that if you look under subsection D, the Board of Trustees reports the results of the election to the Commissioners Court, and then the Commissioners Court declares the results of the election. So that's a little unusual in that normally when we have an election for Board of Trustees, it is the board itself that's the canvassing authority for that election. But pursuant to this statute, it appears to make the Commissioners Court the canvassing authority, declaring the results of the election.
Okay.
It's a little in the weeds and kind of goes against the normal way that elections are run with school board members.
All right. So you're going to get your answers from who? What? You're going to get our answers from which? The Attorney General? Who?
I think we'll have to advise the court appropriately based on our own research and conclusions.
Okay.
We'll certainly be happy to reach out to anyone that the court thinks we can contact.
I asked that question earlier, and that answer made me ask it again. But okay, thank you.
All right, now we move to public comments. First person signed up to speak that I have is Gerald and Jackie Cox. Following Ms. Cox is Dorian Geiger.
Thank you, Commissioners. I am Gerald Jackie Cox. As you watch the news, you will be seeing many reports of fear all around the nation and all around Texas of the deportation efforts that will soon be falling in our community, headed by the sheriff, who much favors deportation, assisted by the governor, who much favors deportation, and to the terror of about 40% of the kids in our public schools who are Hispanic, whose friends and relatives may be adversely affected by this, and to the fear of some of us who stand firmly for civil rights and think that these deportations are an abomination. And I appeal especially to you, Mr. Ramirez, to be sensitive to this because you are the Hispanic representative on the court. This is a time of terror, deep fear, deep division. And what do I find in my commissioner's court? But the police state on display at every door to the courtroom. 3 on the outside, 4 or 5 on the inside. They line the walls. If someone dares to applaud some comment by Reed Bills on how your rules violate the First Amendment, that person is escorted by multiple police from the room. This is the police state, and if you don't think that the fear that you engender by using the police as you do is a form of not very subtle censorship of what we feel, we think we can say, you're not paying attention. But I'm asking that you consider what you do and the fear that you create, and that you do what you could to be kind and to be merciful and to help us through this dreadful, dreadful time.
Following Ms. Geiger, we have Catherine Godby.
I wish to show my support for all of Mason Yancey's family and friends for their well-spoken request for jail reform. I hope their voices will result in positive changes being made in the Tarrant County Jail.
Following Ms. Godby, we have Carla Palomares.
I'm Catherine Godby. I'm with the Justice Network of Tarrant County. I've been coming here about 2.5 years now. I'm concerned for the high number of deaths at the Tarrant County Jail. I have no doubt that there are fine, deeply good people working in the jail. Of course there are. But it's hard, even for the people who truly want to treat others with respect, when they're operating in a culture of willful indifference and thereby a culture of cruelty. 2 weeks ago, Commissioner Simmons read a plea from a mother of an incarcerated person saying that a guard is telling her son, among other things, that he won't get out of there alive. In response, the sheriff said, "Of course we'll look into that. We always do, Commissioner, but 99% of the time it's not true. There's nothing there." Obviously, he's not looking seriously. He's going through the motions, and we assume every detention officer in the jail knows that. So let's be real here. Not everyone, of course, but there are detention officers in the jail who do not treat people with the dignity they deserve. In all likelihood, that mother's son is being terrorized. If this kind of thing did not happen, we would not hear the reports that we hear. We would not have so many deaths in the jail. We would not have to pay out millions of dollars in wrongful death lawsuits. The culture of willful indifference is a culture of cruelty, and it comes from the top. The Justice Network is not even saying that if the sheriff cared about his fellow human beings, we're saying that if the sheriff was competent, then he would begin today to change that culture of cruelty. But we know he won't do that. So it's up to you. Commissioner Kraus, Commissioner Ramirez, you have the power of the purse over him. You have the power to make inspections, surprise inspections at the jail, and you have the power of tremendous influence in this community. If it was your son or your daughter being terrorized in the jail, what would you do? Thank you.
Following Ms. Palomares, we have C.J. Grisham.
My name is Carla Palomares, a resident of Precinct 4. I know the people had all of you pretty shaken up from the first meeting of this year to have brought forth a new decorum policy effective next month. You want us to not be in your ears every 2 weeks and taking up your whole day, then maybe do something about Wayborn, like demanding his resignation and opening an independent investigation into him and the jail, and get us all some real answers about what's happening at the jail and accountability to our communities. Most of you have been on this dais for 2 years now. Color me disappointed but not shocked that 2 of you have only applauded and commended the horrific leadership of Wayborn. 70 people have perished, but I guess when we get to 80 this year, per our track record, y'all might do something about it, or not. This court does have a lot of power. You, as Judge Tim O'Hare and presiding officer, have a lot of power, and the manner in which you wield it does matter. That being said, it's been evident that you use it for your own interest over those of the people. You've shown us very clearly in the past 2 years what type of leader you are, just as Wayborn has shown us what type of leader he is. On multiple occasions, so much that we expect it at this point. When you propose something like that, to have campuses closed as polling sites, that everyone speaking in favor of it does go first. Maybe you should consider the perception the people have of you and this court. Maybe it will be changed in a meaningful way by listening and adapting instead of denying and ignoring us. In 3 months, it'll be 1 year that Anthony Johnson Jr. was murdered in the Tarrant County Jail. We're overdue on accountability and justice. And Sheriff Wayborn, because I know you're sitting in your office watching, we're still demanding you release the court. You release the full video, and this court as well demand that it is released and expose everyone involved and responsible in this murder. The Sheriff's Office, to MHMR, and to JPS.
Following Mr. Grisham, we have Charles Hermes.
Were you arrested?
No, him, right there. Yeah.
All right, so I came here last time because my good friend Mason Yancey was murdered in the jail. All right, that's why I meant to come here, but you didn't hear from me. The reason you didn't hear from me is because the thugs you have outside the door there assaulted me, threw me in handcuffs for no reason whatsoever, and tried to arrest me. Thankfully, Sheriff Wayborn thought the better of valor and listened to me when I told him to read the fucking law. Now, let me tell you something.
Remove him immediately for that comment. Get him out of here.
Excuse me, that's protected speech.
Yeah, it's not going to be protected in this courtroom.
If it's protected speech.
It's ridiculous. This is the problem right here. Let me get my stuff. What the hell's wrong with you people? You're in my way. Let me get my stuff. And Chief Driscoll here needs to be fired.
Mr. Cradaville, is it indeed protected speech?
Yes, it is. I've got the case law right here.
Mr. Cradaville.
Commissioner, I would say that
would be appropriate for me to give legal advice and close on that.
I'm sorry.
I would.
I think it's protected speech.
Well, I believe our policy says you don't allow it.
What
The one
policy?
we just passed and the one before it, so. All right, Mr. Hermes is not present.
What did you just say? What, in response to my question? I couldn't hear you.
It's a more nuanced question than simply me making a ball or strike call at this moment. I would say that so long as the action is in compliance with the court's policy, that's what we should defer to at the moment.
So the court's policy supersedes freedom of speech,
No.
Constitution? Okay. But you'll look into it.
I can give you an answer to that question. Yes, it's dependent on the facts of what's occurred. Yes. This constitutes legal advice, and I would just advise the court to allow us to talk about it in executive session if there's a question.
Somebody could probably Google it and see if it's...
The policy that's sitting here before us that we are following does not allow profane language. So I'm enforcing the policy that is in existence at the moment.
That's fine. That's fucking fine. But I need to know if it
You're
is
simply the most
protected
classless
speech.
person we've ever had sitting on this dais.
Okay. Well, say that again, ma'am.
Johnson versus Campbell is a case law that says we can swear.
Thank you.
Johnson versus Campbell.
We will maintain order. There will be nothing called out again from the audience. We'll just close the room down, let the rest of the speakers come up. So Katie Starnes is next. Following Ms. Starnes did we already have Ms. Cox on public comments? Wasn't she the first one on public comments?
Yes.
Okay. So following Ms. Starnes is Bishop Kirkland.
Hello. I was incarcerated in 2016. My food allergies and intolerances were not accommodated, and I did lose 39 pounds with the 6 weeks of my incarceration at TCJ. And I'm bringing this up again because there is a culture of gross cruelty that has been in place for incarcerated people in Tarrant County that has been continuing for many years, and it needs to end. I remember I filled out a form with the head officer of my pod every single week about my dietary restrictions. Also, my father was constantly sending emails. My lawyer at the time had medical documentation that was presented to the judge in probation court for my hearing at the time, which was weeks before I was transferred to the prison facility. I was still not provided with the care that I needed at the time, and that was the time when there was not a record high death rate in the jail. So I can imagine that if my own health was ignored back then the protocols that we had listened to in the last commissioner's court meeting that are put in place to prevent these deaths don't seem to be prioritized or followed very well. I had witnessed medical emergencies in TCJ with other inmates, and their pleas for help with medical problems were ignored until they literally collapsed. And I do recommend that the protocols in place should be revised and correct prioritizing of medical issues and mental health issues, or even a new protocol should be added to prevent these deaths from happening again. We're not asking you to make people comfortable in jail. We are simply asking you to follow every inmate's constitutional rights, such as avoiding cruel and unusual punishment, the Eighth Amendment, to keep people from dying, and to let inmates have their day in court without dying of preventable circumstances first. So let's allow the Sixth Amendment, which says we have the right to a fair trial. And I also want to mention that it is obvious if somebody was on drugs when they were incarcerated and died days later, that it's not due to drugs. Everybody is searched thoroughly before being incarcerated, even going through a squat and cough before being escorted to their assigned pod and cell. And as a taxpayer, I would like to see everybody involved in Mason Yancey's death to be held accountable. He was too young, and he did not die of terminal illnesses. Thank you.
Thank you. Following Bishop Kirkland, we have Nan Terry.
I have a major question for this court. I agree everything that gentleman stated. I was at the restroom. I heard him at the top of his voice screaming. Why wasn't he put out? Why does that Johnson girl, when she come up here, doesn't reach anywhere the frequency or the tone of that white man's voice, yet he was able to stand right here at this podium and not get put out? Keller ISD, welcome to how you treat people who are the least represented in our city, in our government, in our country. This is how it goes. You could sit here, commissioners, judge, listen to 100% of your constituency, ask you to at least table an agenda item, and you completely ignore it. And then you say you're here for the people. And then you say, well, it takes too long. Well, I looked at how much they're paying you guys. I don't get paid anything to come down here. Yet I set the whole 5.1 hours that it took us to get to the issue about whether or not those campus voting sites would be closed. I did it for free. If I could do it for free, and if you could get paid to do it, indulge us, please. Please indulge us. I cannot understand how people are calling me, how people are emailing me. People know where I live. I don't know what happened to those cards that we give you guys. I see you turn around and throw them in the trash. I don't know if they're shredded. Somehow, the only connection these people have with me, my new fan base, is through this court. And I'm okay with that because I'm never alone. I'm never alone. And I'm always prepared. I do want this court to know that I know when you want to engage with people, like you did the lady that was sitting there, you engage. She called you Maddie. Well, we're not voting today. So y'all engage when you want to engage. You talk when you want to talk, and you're silent behind the ordinances that say you can't speak to us. All of those things are fine with me. I just want to go on record. And I want you to know how displeased that I am that 100% of your constituencies could say something to you in a meeting and you vote however you want to vote. You don't have a vote because you sit in that chair. You have a vote because you are elected officials. That's why you have a vote. If you ever address me in a dialogue and talk to me, I'm going to talk back to you. I'm not your boy.
Following Ms. Terry, we have Rose Abraham.
It's a tragedy that we are here together to discuss another young man's life that was taken while he was in the custody of the Tarrant County Sheriff's Office. It appeared to me that the sheriff dismissed the medical issues related to Mr. Yancey by saying, we immediately put him in detox protocols. According to an open records request, the Tarrant County Sheriff's Office has no standard operating procedures for detox protocols. Nothing. Mr. Yancey died in the sheriff's jail. The sheriff's responsible. It really is that simple. How many others have died under detox protocols? 23 people died without an outside investigation, requirement of the Sandra Bland Act. Of these 23, the Texas Attorney General's death in custody reports, several of these died during detox protocols. But we don't have that outside investigation as required by law. The sheriff was actually non-compliant with the Sandra Bland Act because of these 23 deaths and no outside investigation, according to the Texas Commission on Jail Standards. Do we have outside investigations underway for Yancey or Ramsey? According to the Texas Commission on Jail Standards, Tarrant County Medical Examiner is the outside investigator, but their investigators have to move their license. Is it really an outside investigation if their license has yet to be moved? Was it moved when court started this morning?
Remember that National Institute of Corrections? That's the group with the Department of Justice that funded the site visit and report on the Tarrant County Jail. That same organization was a partner in the development of a legal brief entitled Managing Substance Withdrawal in Jails, which I passed out to this court commissioners meeting last year. If you can't find it, you can Google substance withdrawal in jails and find it. I quote from the brief, "Deaths from withdrawal are preventable, and jail administrators have a pressing responsibility to establish and implement withdrawal policy and protocols that will save lives and ensure legal compliance." Perhaps the sheriff can ask his new hire to create detox protocols to prevent other deaths. This new hire has extensive experience at the Commission on Jail Standards and could create a protocol to protect the health and safety of people under his care. If the sheriff's office fails to create such protocols, perhaps you can fund them. As you deliberate in the closed session, perhaps you could ponder spending money to develop detox protocols for jail staff. That's got to be cheaper than more settlements. I urge you to ensure compliance this morning with the Sandra Bland Act. This morning, as we said allegiance to the state of Texas, I thought, what a mockery. How can you pledge your allegiance yet knowingly fail to follow the Sandra Bland Act, requiring outside investigations and custody? How can you?
Is Rose Abraham here? All right, next we have Carolina Rodriguez. Following Ms. Rodriguez, we have Jimmy Blackwell.
My name's Carolina, and I have a small freedom of speech YouTube channel. Kind of small. It's got 100,000 subscribers. The second one with 20,000. Facebook with another 20,000 subscribers. I mean, people know my name. If I walk outside, they don't know yours, Mr. O'Hare. But I forgot. I'm in front of royalty, so I forgot to bow. I got to apologize for some of the clothes I've worn in the past. I've worn T-shirts and overalls, but because I kept forgetting I was in front of royalty here. So I just also want to say that arresting somebody, like you did last week, or your hoodlums did back there, for retaliation, for exercising free speech rights is sufficient to kill free speech and is an understatement. That comes from case law that some people around here don't know, called Beckley versus the City of Upland, arguing if even loudly with profane language will not and of itself constitute disorderly conduct. That's Payne versus Polly. So swear words alone don't mean that it's disorderly. Swear words do not provide probable cause for an arrest for disorderly conduct because the words as a matter of law are not fighting words. And that's Johnson versus Campbell. So your rules of decorum policy cannot trump the laws of the United States of America. So your rules of decorum are setting your county up for liability. We have the right to say fuck, shit, damn,
remove her
bitch.
immediately.
We have the right to say all these words because it's a First Amendment right and you can't do anything about it. In the Stillman case, right? Fuck you!
All right, Mr. Blackwell, you're up. Following Mr. Blackwell is Daniel Freeman.
Prior to the 2024 election, I stood behind this podium and said that one way or another, this election will make history. Whether voters elected its first African of the diaspora woman or its first dictator in training, the vast majority of voters chose the dictator in training. Also, I warn voters that America is on this slippery slope towards utter and ultimate destruction. And based on who was elected will determine the acceleration towards this destruction. Again, voters chose to go with the master accelerator, the mega godfather. Yesterday was was the first week anniversary of the installation of the mega Godfather as America's leader, and you see that the speed towards America's utter destruction has already increased tremendously. And this is only after 7 days in office. Be aware that there are a lot of 7 days in 4 years. Remember this biblical principle. You reap what you sow. And America is about to reap what they sowed in November. Evil cannot and will not prevail. Even though we have evil people in positions of authority, making horrible and disgusting decisions daily, evil will not prevail. You know, I was sitting here, and from the back of the room, you look like Beto O'Rourke there, Mr. Krause.
I don't know who that is, so I don't know if that's a compliment or an insult, so.
No, wait till I finish.
Okay.
But as soon as you opened your mouth, I knew you were the devil.
Okay.
Mr. Freeman, is Daniel Freeman present? Is that you, sir? Yes. Okay, following Mr. Freeman is Robert Bucher.
So what I've witnessed today is just more of what I witnessed last time, which is specifically you, Judge O'Hare. You're not acting like a judge, you're acting like a tyrant. These rules, these new decorum rules, they violate the First Amendment very clearly. And that one was stating multiple case law on why that's a violation of the law. And what did you do? You had her taken out and falsely arrested. Now she's back there, who knows what they're doing to her. And if she ends up in that jail where 70 people have died since Bill Wayburn took office, you know, what's going to happen to her? I don't know her medical conditions and if she needs medication, if they're going to deny that to her. And what are you guys going to do about this? Are you going to do anything? You never answer, you never even make expressions. Like the only time I see you really talk to people or anything is when you tell them not to do something and then you have them removed. That's all I see you do. So when are you going to take this seriously? When are you going to take these deaths in custody seriously? And when are you going to take your duties and responsibility to uphold the Constitution seriously, and your duty as a public official to protect the people who you serve, like all of the 70 people who have died in those jails? There's a problem when 3.5 times more people have died in the Tarrant County Jail than the national average. There's a very clear problem, and it's not being addressed at all. The only person up there that I see addressing it and taking it seriously is Commissioner Simmons, and I thank you for that, and I am glad that you represent me. But I do not see anybody else who ever says anything positive about trying to change things. And so I just don't understand how you could be so heartless. I don't understand how you could think that throwing people out, one person twice, you've had him thrown out and arrested for nothing. clearly violating the First Amendment and many others. And so I have 4 constitutions for you guys, but you especially need to read
Your time
this,
is up.
Mr. O'Hare.
Thank you.
Because I don't think you've ever read it.
Your time is up. Mr. Bucher?
No.
The Americans with Disability Act, disabled inmates are entitled to receive the same level of necessary care as they would have received before being incarcerated, meaning they should not be discriminated against based on their disability and must be provided reasonable accommodations to meet their specific needs while in prison and or jails, and this covers jails. So while my son's not getting his medicine, and if you want to address me on it, here is his medical file that it took me a whole week to get. A whole week to get this, to find out that he's getting certain medicines withheld. He has a congenital heart problem. He's in congenital heart failure. So when I visited him yesterday, guess what I find? He's swollen in the face, which means he's retaining fluid. Bad for his heart. You want to make 66 jail deaths? Hold Wayborn accountable, or not hold him accountable. That's how you get 66 jail deaths. I'm highly concerned. He needs to be released immediately. He's based on false allegations. They're in a corrupt judge that needs to have her whole budget squandered. Whole budget, and I mean whole budget. She doesn't need to operate at any given time. And I will tell you, I'm looking at it right here. He's not getting his furosemide, which is a diuretic he's supposed to get twice a day. And they've been withholding it. They withheld it at JPS. They withheld his psychiatric medicines for a while. They just recently started giving them 3 days ago. But man, we're doing so good. JPS is doing a wonderful job. But I got all the proof right here that shows they're not. Blood pressure at 90/52 is deadly for a cardiac patient. It's bad for us, deadly for him. And this has been on 4 or 5 occasions in the notes. And also in the notes, there's a doctor that begged and pleaded to Cook's Children and to UT Southwestern to please take him because we can't handle him. And a nurse also told me we don't have the cardiac specialist or the means to be able to handle this complexity of a case because he has PLE. And if you're not familiar with that, that's where your protein dumps either in your pee or your stool. And he happens to get in the stool, which dumps 3 times as much, which weakens his heart. And guess what? He just sits there in the cell now. Thank God he's not back at JPS. He can at least walk around and not be chained to a bed like a dog. That was the hardest thing to see. My little 115-pound, 23-year-old kid who got falsely accused and was able to plea out to something that he should have never had to plead to because of a piece of crap. A piece of crap, the public defender, who was going to lay down and throw the case. So we had to take the best deal we had. And he made it very clear he was going to throw it. Every time I asked him what's going on with the case, what's going on with the intricate details, oh, it's a 50-50 thing. Okay, 50-50, you might be 100 to me, or 80-20, or 80-30, 70-30. But that's what we have to deal with. But no, we're going to sit here and we're going to keep making excuses for this sheriff's department, for the JPS, and not do anything about it. And thank you, Ms. Simmons, for doing what you do. Because it's people like you that give me a little bit of hope, not much, but a little bit. Thank you.
I'll help you get the medical help you need. That's my chief of staff right there.
All right, do we have any announcements or comments from the court members? Anything from the court members? All right, seeing none, the Commissioners Court will now recess the open session and proceed to closed session to discuss items exempt under 551071, 072, 074, 076, 087, and 0725 of the Texas Government Code. We are now in recess. Executive session will begin at 1:22.
22.
I got 2 resolutions. Is there a reason why I had 2? We're done.
Got it?
I think when it switches that screen,
Got
it's
it handled?
live. Yeah. All right, we're going to close it, and if it isn't, I'll come back. All right, we're back from executive session. There's no action to take at this time, so this concludes our meeting. We are officially adjourned.